Tangita kaua ka wea wai o ke tangi ana. Tangita parauroa wai o ke tangi ana. E tatari atu ana ki aroaroma ana ka taka mai rā te a uru kōia. Kōia tēnei ko te whenua ko te papa kōrero nei o te rōpū whakamana i te tiriti o Waitangi. Ki aro atu ki tēnei te ara i haike mai ai te ira wahine, te mana wahine, te tapu wahine e whakaari ana ki roto e ngā kōrero e hora ana ki runga i te tēpu. E mihi ana ki tēnei ki tai wiwi, tai wawā, tai whawhati nei ki runga i tēnei te taku tai moana o kōrero o kupu o wānanga ki are wā atu ki te taumata whakaaro nei o te kaupapa e hora ana. Nō reira e mihi ana ki runga anō i te āhuatanga o tātou kuia, o tātou oaene, o tātou tuahine, katoa kua huri atu ki tua o te ārai, kua tōia mai ki roto i te whare i tēnei rangi. Nō reira, tērā anō ki roto i au, i roto o Waitara, e takoto ana ki reira, a mana morehu, ko ia tētahi e mōhio nei au. Engari, tērā anō kai au koutou. Ngā mate kua tōia ki roto i te ngā kōrero, ko waihoa nō mā koutou e whakahuahua. I ngā wā e pai ana. Nō reira, mihi ana ki a koutou. Ngā rōpū katoa i tae mai ai ki te whakatakoto, i tēnei mea a wawata a tūmanako, nau mai, e rarau ki tēnei ki te ore. E rarau ki roto i tēnei tēpu, tō tātou kaipakawā o tēnei anō ngā kaupapa, e mihi ana, me te mea hoki, ana ka waihoa anō, mā te kōrero tātou e arataki. Nō reira, ka waihoa atu i konei, he whakatau. Whakatau i te kaupapa i te rangi nei, whakatau i o koutou mate, whakatau i tō koutou ora, tō koutou māia, tō koutou manoa nui, e rarau, e rarau, e rarau mai rā. Te motu nei ki roto ko ia o pari akana, tō urai waka aere mai ngā tikanga i tere pai ai te motu nei. Tō piki tanga kai te pure poto, e ke tanga kai toroa nui ki a waka, rongo ko e ki te reka mai o te kōrero, ei, ei, ei. Mātou tonu au ki a koe e tō ue te ngāka, waka puke tonu mea aiara, e mauru e ko te au, ka weru waka mō motu e viu an, kei te uru e kei te tonga, ka arama i roto ka ko ari, ei. Waiata tērā i roto o Pariaka, no muaupoko te waiata. Pērā no te kōrero ana i te wai haramai te hōia, ko wai te tuatahi ka tukunātu e tamariki. Ko wai te tuarua, ko ngā wahine hari kai ana. Kia ki atu ko te mau ngā rongo ki runga i te whenua, ko te mau ngā rongo ki runga ki tātou te tangata. Ka ki ko tūtama wahine i te wā o te kore, ko tūtonu ana i te rangi nei. Nō reira tēnā koutou, tēnā tātou. Ka ea atu i konei te ahua o te mihi atu o tēnei taha. Ko whakatau i a koutou. Tērā nōpea, e hia ne e te hiki te whakautu i tēnei mihi, o waiho atu mā koutou. Engari, ana māku te tehi karakia, kia whakawāte atu i tēnei wāhanga, ka tahi mehe mea he mihi, me tū ki te mihi, engari anō ki te kore, kei te pai, ka waiho atu mā tō tātou kai whakawā, ana e tuku i ngā kōrero. E pai ana, e mārama ana, kōrero Māori nei. Hei rere tonu ana te wiki o te reo Māori ki runga i a tātou. Nō reira ka tuku atu ko tēnei he karakia i runga i ngā manu e rere mai ana. E rere mai ana i runga i tēnei, e rere ki runga i te whenua i runga i te moana. E rere te au whenua, e au moana o ka roro ki tai tonga, ki tai mauru, ki te o tū, ki te o whenua, ki te o tangata, nā inea uone. Tēnei ka whai tapuai, tēnei ka whai taumata, tēnei ka whai marae whare o ngā mātua i au e ngaro nei, e au e tū nei. Hoa i e au taku tapuai, he hoa tapuai no tāne, he hoa tapuai no tūmatauenga. Hei hoa whakapakari nō rongo, tēnā kia whakanguha mai, tēnei piringa e tū mai nei, ko ia e rongo, whakairea ki kirunga, turuturu ofiti, whakamaua kia tīna, ui e, nō reira ka tuku atu te Māori kōrero, ki te kore, ka hoki mai anō ki tēnei tēpu. Tēnā tātou.
Me aro koe, ki te hā o hine ahu one. Tihei mauri ora ki te whai au te ao marama. Ko te mea tuatahi, ki te atua i runga rawa, ko ea te ārepa me te omeka o ngā mea katoa, nō reira he hōnore he kuroria ki tōna ingoa tapu. Ki te mana whenua o te upoko o te ika o Māui, tēnei te mea atu kia koutou. Ki ngā tini mate kua whiturangi hia. Ki ngā mate uruta o te ao, i tēnei wā taumaha. Haere atu rā, kai tua o te ārai. Noho mai rā, i ngā ringa o te atua. Hokinga mai kia mātou te kānuhi ora. E ngā wahine toa, e ngā kai kreme o ngā iwi take o te motu nei. Tēnā koutou. Kia koe, e te pautoko manawa o te reo Māori, Tākuta Hond. Tēnei te mihi kia koe, mo tō mihi whakatau i tēnei ata. Kia koe hoki, e te kai whakawā, e te uri o Ngāti Awa Te Atiawa, tēnā koe. Tākuta Anderson, tēnā koe hoki. Kei konei ngarimu? Ko tai mai tātou, ko whakameninga mai tātou. Mō tēnei kaupapa tino whakahirihira, ko te mana o te wahine o tira, ko tai mai ki te whakarite-ritea, te kaupapa e whai ake nei. Mō tēnei kaupapa whakahirihira ko te mana o te wahine. He mihi poto tēnei, nā reira, he whakatāpinga māku, ko Waia Hau, ko Himi Losa Hau, nā Ngāti Whiti Kaupeka, ko Kaupeka ki runga, Kaupeka ki raro, whiti kui ora e. Nā reira, tēnā koutou katoa. Kia ora. Tātou e, tūtera mai ngā iwi. Tātou e, pai a te maramatanga, me te aroha e ngā iwi, ako tapatahi, ki ako tahira. Tātou e. Mā te atua e manaki e te aki, kāpiti hono, tātai hono, te hunga mate ki te hunga mate, kāpiti hono, tātai hono, te hunga ora ki te hunga ora. Tēnā koutou katoa.
Tēnā tātou. Tēnei te mihi ki a koutou, nā kai karimi, me ngā roia, kua tai mai i te kaupapa o te rā. Tēnei te mihi ki te hunga matakitikiti hoki. Welcome everybody to this judicial conference of the Mana Wahine inquiry. First of all, just cover a few housekeeping matters before we get into our conference proper. So our panel this morning, I'm joined this morning by Dr. Hond to my left, Dr. Anderson to my right. Unfortunately, Ms. Ngarimu has been unable to join us today. And at short notice, and sent us her best wishes. Her father has been taken ill suddenly, so she's had to return to Gisborne. So the program for today, we will be sitting through in this session until 1 p.m. when we will break for lunch. I'll break for lunch from 1 to 2. I understand there will be some kai available for council and attendees in our wharekai. At that time, we will resume again at 2 p.m. and we'll sit through till 3:30 when we will break for some afternoon tea, and then we will recommence at 4 until we're finished our business for the day. Now, we did have a fire alarm last week, so I should just state that in the eventuality of a fire alarm or an earthquake, we proceed down the stairs, which are to the right of the lifts here, and those stairs take us out into Cable Car Lane, and we assemble out on Lambton Quay, where we will be hopefully accounted for by our fire marshals. I think that covers all of the housekeeping matters for the day. The schedule, the agenda for the day has set out the matters that we will be working through. So I intend this morning to start off with really looking at the subject of research, so the exploratory scoping report, together with submissions concerning any additional research to fill gaps in that coverage. We'll also look to have some kōrero around the progress in terms of the research committee, and also some kōrero around the claimant and research funding as well. So that should probably, I think, take us through to lunchtime, and then we will move into the other matters which are listed there on the agenda, planning for the tuapapa hearings, and we have the dates for those. We really are just looking to finalise what's going to be our venue, and then claimant eligibility together with any other matters that council wish to raise. Before we start, are there any matters that council wish to raise now as a preliminary issues?
Your Honour, council's name is Loda, and just as a preliminary matter, on the 2nd of October, council filed a memorandum of council in advance of the judicial conference after meeting with claimants, and would like to seek leave for that to be filed on the record. 12 copies were passed on to tribunal staff earlier this morning.
Thank you, Ms. Loda. That was received on Friday afternoon, I understand, and so I have had an opportunity to review that, and leave is granted for that to be entered onto the record of inquiry.
Thank you, Your Honour.
Thank you. Any other matters? All right, no. Well, let's make a start then. Yes. So, to start, if we could take appearances from council, and I am happy for that just to proceed from my right and to move through the room. Ms. Mason.
Thank you, Ma'am. I appear this morning with my friend Ms. Lydia Oosterhoff, who is having her first appearance at the tribunal this morning. And we represent a number of clients. I'd just like to read the document number which lists them all on, because I won't be able to list them all. It's document 3.1.275A, and our clients are a number of the district Māori councils, represented by Mrs. Tirewhai Harawera, Mr. Cletus Manu Paul, Mr. Des Ratima and Mrs. Diane Black and Mr. Rihari Dargaville. And then we have Mrs. Collier, who's a separate client. We represent Ahi Wihongi on behalf of the Gender Minorities Group and Māori Women Sex Workers. We represent Ange Cheney on behalf of Māori Women's Refuge, Y2875. Mrs. Tiamohia McQueen and Albert McQueen. Mere Mangu on behalf of Wahine and Tamariki of Ngāpui. Moerenga Potiki, and she's from Ngāti Whakawe. And Api Haka Mac, and she's from Ngāti Awa ki Kapiti. Beverly Wiltshire Rewati 2850, Repeka Ormsby 2934, and as I said earlier, Ma'am, there are a whole lot of others listed on that document number. Thank you.
Tēnā tātou katoa, tuatahi ki te haukainga o te rohi, te Aotearoa, kei te mihi. Ka huri ki te whare e tu manei, kei te mihi. Kia koutou ngā pou o te tepu, e ngā rangatira ka nui te mihi. Lauda te ingoa. I am appearing for several claims here today, and with instructions from Cameron Hockley to represent his claims also. I am here for the wahine of Ngāti Hau me te Parawhau, Ngā Hapu o Whangarei. These are claims by Bonnie Jade Kake, 2717, concerning Māori in prostitution. A claim by Hannah Maxwell, 2855, concerning Mana Wahine leadership. Huhana Linden, 2884, representing Mana Wahine in local government. Thelma Connor and Christy Hinare, Y2917, on contemporary land law and wahine Māori. Tēnā koutou katoa.
E te kaiwhakawa, tēnā koe. Honoured members of the tribunal, tēnā kōrua. Our council's name is Ralton, and I'm appearing today on behalf of Jasmine Cotter-Williams, her whānau, and members of Ngāti Tai Mana Waiti, that's Y2063. Denise Egan, her whānau, and members of Te Mahurihuri, Y2005. Robert Gable on behalf of Ngāti Tara, that's Y1886. Annette Hale on behalf of the late James Tupi Wikitu, their whānau and wahine of Te Upu Korehi, that's Y2743. Tianga Harris and Lee Harris and the Harris whānau, Y1531. Evelyn Keriopa, her whānau and members of Te Hui Ngārangi, a hapu of Maniapoto, Y762. Catherine Nicol and Sonia Matheson, on behalf of the late Kathleen Nahuia Marden, the late Emma Gibbs Smith and their whānau, that's Y1488. Mel Mata Ormsby, Daniel Ormsby Tiaho, Meri Pilo and Manu Patina for and on behalf of themselves and members of Ngāti Tamakopiri, Ngāti Hikaro and Ngāti Hotu, Y1196, Bryce Peter Smith, Stephen Mark Renata and Russell Owen Smith on behalf of Ngāti Pākehī, that's Y2377. Ruben Taipiri Porter, his whānau, and members and descendants of whānau Pāno Tahawai, Kingi Tangata Hapu, that's Y1968, sorry. Wiramu Reihana on behalf of his whānau and members of Nai Tautahi ki te ringa, that's Y1957. Okiro Rogers, her whānau, and Ngāti Kohereki, that's Y2869. William Tauaki, the late Ron Tauaki, their whānau and Mupoko, that's Y237. Susan Taylor on behalf of the Taylor whānau, that's Y2729. Mona Verco Cliff on behalf of her whānau and wahine of Nai Mahi, Hapu, Y2863. Violet Walker on behalf of the members of Ngāti Uru and Te Tahawai Hapu, that's Y2382. Also Violet Walker as a member of Ngāti Kahu, Ngāti Rangi, Ngāti Parau and Ngāpui, and that's Y2818. Charlene Walker Grace and members of Te Hokinga Mai, E Te Iwi, o Ngāti Whātua, Ngāpui Nuatono, that's Y2206. And Michael Williams, on behalf of his family and wahine of Ngaitupango and of Māori wahine survivors of family violence, that's Y2838. I'll be making submissions on behalf of our claimants in relation to the pre-casebook discussion paper, which was given the appellation number of 31288, and also on behalf of Claimant Council in relation to coordination matters, that's document number 3.1280. Thank you, Mum.
Just while you're on your feet, Ms. Rowden, just to clarify, the memorandum, the joint memorandum of council that was filed didn't include submissions on the casebook, did it?
No.
So that will be for council who wish to make their own, those council who are otherwise included in that memorandum will be making their own submissions on that
Yeah,
matter.
we didn't take a coordinated approach to those
Okay.
submissions.
All right, thank you. That's just to clarify.
Thank you, Mum.
Kia ora.
Kia ora.
Good morning, Tribunal. Donna Hall here with Miss Ranchard making her appearance for the New Zealand Maori Council. If I can just raise a matter, we will put submissions in about it. We've given quite considerably detailed submissions to the Oranga Tamariki Tribunal, and we will flag that we'll likely ask that they be brought over before this tribunal as well in relation to a jurisdictional matter concerning the New Zealand Maori Council. My friend Ms Mason has indicated that she represents certain district councils. We'll be tabling 2 High Court decisions given by Justice Churchman confirming that there is a jurisdictional problem when the council has clear powers to indicate who may bring a claim before this tribunal and the steps that must be taken within the council for there to be a legitimately placed claim. Here it's a jurisdictional claim, and those jurisdictional points have not been followed. We will table it. We do not need to take time up here. We just flag that we'll put it into writing. Perhaps both tribunals might hear the same issue together.
Thank you, Ms Hall. Mr Lewis.
Yes, Mum. I'm appearing this morning on behalf of Y1504, which is a claim by Hirafati Sarank, and Y1913, which is a claim on behalf of Te Iwi or Ngāti Tūkōrehe. Thank you, Mum.
Tēnā koe te kaiwhakawā, me ngā mema o te ropu whakamane te Tiriti o Waitangi, tēnā kōrua, me ngā kaimahi o te Taraipunara, tēnā koutou. Council's name is Hauraki, and I'm appearing today with my friend Ms Judge on behalf of Professor Paparangi Reid and Ms Ripika Evans, who are 2 of the named claimants on the Y381 claim and who are also the named claimants on Y2260. Tēnā koutou.
Tēnā koe Mum, I te tūrahi. E mihi tēnei ki te haukainga o te rohi nei, kia te atiawa, Ngāti Awa, kia Ngāti Toa, ka nui te mihi kia koutou. Te tuarua kia koe te tākuta. Nau e whakatau mai, nau e pohiri mai, nau e kārakia mai i te ata nei. Nau hoki ki whara te hui i tēnei rā. Kia koe hoki te kaiwhakawā, ka nui te mihi kia koe. Kia koe hoki a Dr. Anderson, ki te tepu katoa, mi ngā kaimahi o te Taraipunara, ka nui te mihi. Ki a kui hoa, tēnā koutou, ki a Himi Lewis, nau i whakuutu mō mātou. Tēnā koe mō tēnā. Kia ora Mum, ko take ingoa koe Himi Tanahu, e uri o rongo mai wahine. te atanga hauti rongo whakata, whatu apati, ngati hini pihinga. Kei kua hau te manga ture mo ngā hapu o Kereru, kei konei titei o ngā hapu o Kereru. Hara mai ia ki te tautoko te kaupapa i tēnei rā. Ko te nama tahi i wā whāwha. Ai, kia ora rā.
Tēnā koe te kaiwhakawā, ngā mema o te Taraipūnera, te Karauna, aku hoa mahi, tēnā koutou katoa. May it please the Tribunal Council's name is Ms Jamison, and I appear on behalf of Ngāti Hine, which is Y682, and Te Kaputai, which is Y1464 and Y1546. Kia ora.
Tēnā koe te kaiwhakawa o tira kia koutou katoa. Council's name is Doherty Ware. Council's name is... I think it's turning itself off. Council's name's Doherty Ware. I'm appearing on behalf of 10 claims, and I'll read those ones out. So that's a claim by Hami, Whakatari Kireopa, Angeline Ngāhina Greensill, and Vivian Te Urunga Morau Kawharo, on behalf of Ngāti Koata, Ki Whaingaroa, Ngāti Kahu, Ngāti Tāhau, Ngāti Te Kore, Ngāti Pū, Koro, Ngāti Te Kaunahi, Ngāti Tira, Ngāti Heke, Ngāti Rua Aruhe, Ngāti Hounuku Paitoka, and Ngāti Te Karu, that's Y125. A claim by Arapeta Wikito, Pōmare Hamilton, on behalf of the descendants of Pōmare, the second, and members of Ngāti Manu Te Uri, Karaka Te Uri, o Raiwera, and Ngāpuhi ki Taumārere tribes, that's Y354. Also a claim by late Hone Kāmeta, Te Rua Raku Raku, John Terehita Pio, Paione Gunan, Te Ringa Hui Hata, for on behalf of Ngāti Ira o Waioweka, that's Y558. A claim by Ariana Simpson, Duahine Albert, Catherine Ann Mitchell, Anne Hartwell, and on behalf of Te Whakaruru Hou Waikato Women's Refuge, that's Y1885. A claim by Donna Awatere Huata of Ngāti Whakaue and Ngāti Parau on behalf of all Māori women, that's Y2494. A claim by Hine Raumoa Te Apatu on behalf of Te Runanga o Aotearoa, Tōpūtanga Tāpuhi Kaitiaki o Aotearoa, Y2713. A claim by Sharon Campbell for on behalf of herself and her whānau and for the benefit of ngā uri whakaheke a rangi huatake rā wakohami parehe, pate hepa tāpono tipine te peha tūtaki tamatea rā wakohana ko newa, that's Y2728. A claim by Brenda Riki and others on behalf of Te Runanga o Kirikiriroa, Y2807. A claim by Dr. Leonie Pihama, Angeline Greensill, Miriana Pittman, Hilda Hawkyard, Hara Wera, and Te Ringahuia Hata, Y2872. And lastly, a claim by Te Ata Whaineira, Te Rangi Jade Stevens, Ginny Shepherd, Shemaine Anaru, Tahau, Tasi Huirama, and Amelia Taniwha on behalf of all Māori women and their whānau in gang environments. And that's Y2874. Tēnā koutou.
Tēnā koe te kai whakawā, e ngā takuta, tēnā kōrua, e ngā kaimahi o te rōpū whakamana o te Treaty o Waitangi. Tēnā koutou. May I make a special mention of Mr. Allen in the corner there, who has followed us around already. This is his third week, and while we've been resting up over the weekend, he has been packing up, driving, setting up, and so on. So I feel a special honourable mention ought to be made of him. May it please the Tribunal, Council's name is Gilling, and I appear this morning with my learned friend, Ms. Hu. We appear on behalf of 6 claims. Y58, Patricia Jane Taurua and Robin Taurua on behalf of Ngā Hapu o Whangaroa. Y972, Edward Tautahi Penatito and others on behalf of themselves, the Kowhata Treaty Claims Committee, Te Marae Committee o Kowhata Trust, and Ngā Uri Tangata o Ngāti Kowhata. Y1661, Moana Nui a Kiwa Wood, Waitangi Wood and Terry Smith on behalf of themselves and the descendants of Ngāti Rua ki Whangaroa. Y2188, Daisy Tihi Noble and others on behalf of themselves and the Kānehi Umutahi me Ete he Hapu. Y2389, Tahua Mari Kawhena Paul and others on behalf of themselves and Ngāti Rua Mahue. And Y2922, Manu Te Whata and Taura Te Whata on behalf of themselves and Wahine Māori. May it please the tribunal.
Thanks. Tēnā koutou katoa, council's name is McGee. I appear for 2 claims. Y836, claimed by Patricia Hanari and Vivian Korpua on behalf of their whānau, and Y2157, claimed by Hini Ranganui, Jenny Tamakehu and Hini Moa Ranganui Mansell on behalf of their extended whānau.
Kia ora.
Tēnā koe e te kaiwhakawa. Council's name is Curtis. I appear on behalf of Ms. Wan, who's on maternity leave at the moment. We are appearing on behalf of Y144, a claim by Vern Winitana on behalf of Ngāti Ruapani on the southern side of Lake Waikiramoana. Y1092, 1787, 1758, claims on behalf of Upokorehi. And Y375, 520 and 523 on behalf of Anaru Kira in the Whangaroa Harbour.
So does that account for all council who are in the room, apart from the Crown, of course? I'm just, if that's the case, then I'll move to those who are appearing by Zoom. So I'll just take those off the sheet that's before me. So we have an appearance on behalf of Ranfurly Chambers. Ms. Thompson?
Ai, tēnā koe e te kaiwhakawa. Can you hear me?
Yes, yes, we can.
Kapai, tēnā koe. Korua ko te pauwhakamani te tiriti o Waitangi tēnā korua. O ngā kaikrimi ngamihi kia koutou. O tātou hoki, kia ora hui hui mai tātou. May it please, Your Honour, Councillor's name is Ms. Thompson. Puto mai I Waikato with Monsieur Hirschfeld and Tupara, who will be attending from Tāmaki Makaurau. But only for part of the day, Mum. We appear for several claims today, being Y2912, Rimu Abraham, Y2493, Rita Bickman-Flay, Y475, Wanda Brevelich, Y2072, Makarita Kiko, Y2217, Violet Nathan and Maringi Te Aroha Broughton, Y2371, Tracy Rawson, Y2854, Sybil Rickett, Y2817, Nick Tupara, Y2825, Diane Wright, Y2819, Tahe Simpson. Amihi.
Now, next on my list, Ms. Thornton.
Tēnā koe, Mum. Tēnā koutou te tapu. Councillors, Ms. Thornton, I'm here on behalf of 2 claims. The first one is Y1666, a claim by Ani Taniwha on behalf of her Whangaroa Hapu, Ngāti Kawo, Ngāi Tupango, Ngāti Hayati, and her whānau Na Uri o Tupona. And the other claim I'm appearing for today is Y1629, Vivian Toeki, on behalf of her Mopoko Hapu Ngāi Tamarangi. Thank you.
Thank you, Ms. Thornton. And we have from Te Mataloa, I think I saw Miss Launga.
Tēnā koe, ma'am. Tēnā koutou katoa. May it please the tribunal. Council's name is Ms. Leonga, appearing alongside Ms. Evans today on behalf of the claims represented by our firm. There is a large number of them, so I won't take you through them individually, ma'am, but they are listed in Memorandum of Council 3.1.284 as well as 3.1.283. Tēnā koe.
Tēnā koe. Do we have an appearance from Te Ha Legal? An appearance, Ms. Chestnut, you're appearing for Dixon & Co.
Tēnā koe e te kaiwhakawa e rongo mai ana koutou?
Ai.
Tēnā koe e te kaiwhakawa tira ki te tepu whakamana i te tirito o Waitangi. E mihi ana kia koutou katoa. Ko Ms. Hirawini Ahau. Ko tai mai maua ko Ms. Chestnut. More Dixon & Co. Lawyers. Tēnā koe, ma'am. Council's name is Ms. Hirawini, appearing with Ms. Chestnut for two claims. One on behalf of Patu Harakeke, and that's Y745 and Y1308. The second is a claim by Aroha Rerete Cross for the Māori Women's Welfare League. Ms. Rerete Cross is a named claimant for the Y381 claim. Tēnā koe.
Mr. Whenua?
Tēnā no ki tātou. Tuatahi e tikana me mihi whakutikia koe e te rangatira e takta hond o tō mihi tēnei ata rongo i tēnei whakatoa atu koe I tō mana I rongo I a tātou katoa me te mana o te atua nā reira kai te rere aku mihi ki a koe. O tira ki te tēpū rangatira nei tākuta Anderson ko korua ko te tō tātou kai whakawā Judge Rees kai te mihi atu ki a koutou. Ki te tribunal anō hoki, te whakahaerehia I tēnei ko tō tātou kaupapa nunui rawa ki a tātou katoa kai te mihi ki te karauna me kia kuhua mahi, roia kai te mihi. Ko taku ingoa, ko te whenua, I tēnei rā kai te kawea nā kreme o Tina Barnett, Sharon Deatafai Barton, Ray Brown, Lee Cooper, Sid Kepa, Loris Park, Muriel Tunoho, Grant Williams, Aubrey Wilson, mō te runanga o ngā kaimahi Māori o Aotearoa, the runanga of the New Zealand Council of Trade Unions, wai rua waru rima iwa. Me te mea hoki kei te kawe nei, hei māngai mō te kreme o Paula Davis, Lani Harding, Georgina Kerr, me Alan Franks mō William Newton, mō te runanga o ngā toa whina, te runanga o the New Zealand Public Service Association, wai rua waru ono whā, me te kreme o te hapu o nai tamatea, mō ngā uri o te waru tamatea o Kaita Hudson, wai tahi rima tahi. A kia ora.
Ms. Clark.
Tēnā koe, ma'am. Tēnā koutou katoa. Ko Raywin Clark, toko ingoa. I appear on behalf of Y1781, which is a claim by Tracy Hillier and Rita Wordsworth on behalf of Ngāi Tamahoa Hapu. And one small administrative matter is to add the name of our firm in support of the a joint memorandum of council that was filed in preparation for this JC. Due to an administrative error, we didn't make it on to the final version, but we are also in support. Kia ora, ma'am.
Kia ora, Ms Clark. Now, I think I saw Mr Sharrock. Is Mr Sharrock there?
Tēnā koe, Mum. The council's name is obviously Sharrock. I'm here representing two claims. 2179, 1941 and 2179. The first, 1941, is with Huhepapini and Mara Stead on behalf of Ngāpuhi women with reference to mental health and solo women and the role of grandmothers, while the claim of Mihari Dagaville is on behalf of his mother in the Wahine of Whangaroa with specific reference to fishing and other resource rights. Thank you, Mum.
Thank you, Mr Sharrock. Are there any other claimant counsel who I haven't received an appearance from? Okay, thank you. Now, the Crown.
Tēnā koe te kaiwhakawa, tēnā koutou e ngā rangatira, ko Liesl Turon, ko Matawai Tukapua, o Maua Ingoa, e tuana Maua he mangai moe te karona, tēnā koutou katoa. May it please the Tribunal, Council's name is Ms Turon and I appear with Ms Tukapua for the Crown. Thank you.
That concludes appearances. So now we're going to turn to the first matter for the day, and that is the issue of the exploratory scoping report and any proposals for additional research to fill gaps in the evidential coverage. Now, you can take your written submissions as read. So what I'm going to do is to give an opportunity for you to highlight any key submissions that you wish to make on this subject, as opposed to taking us word for word through what you may have filed. I'm aware, as I clarified with Ms Roughton, that the joint memorandum of council doesn't cover this particular subject, so there will be an opportunity for everyone just to give us their view or the reasons for the views that you have expressed in your memorandum in relation to the research coverage. So on that note, I'm going to start with Ms Roughton. Do you wish to make any submissions in relation or highlight any submissions? Obviously not on behalf of Joint Council, but in terms of the other memorandum that you filed on this subject?
Yes, Your Honour. Shall I?
Yes. Yep.
Thank you, Mum. It's just a little bit easier from this table. So the document that we filed was document 3.1288. So I just want to highlight a few key submissions that we set out in our written submission. So just firstly to note that we made several research proposals in our submissions. I just want to make a couple of comments to begin with, just to provide some context for our submission. So we're cognizant that the Tribunal may not be able to commission all the required research, and given the mahi that we've been undertaking in order to progress the work of the Joint Research Committee, we're also hopeful that there may be some changes to the proposed research in this paper as recommended by the Chief Historian as a result of these submissions. In addition, we are also anticipating the opportunity to make further submissions to the Joint Research Committee. In addition to that, given the limited funding available to the Joint Research Committee, we wish to highlight that we expect there to be further gaps in the research program even after the Joint Research Committee has commissioned research. Now, while some of those gaps may be filled by a shared research agenda, as noted in the Crown's latest submission, we think that it may not fill all those gaps. So, therefore, we're respectfully requesting that where the tribunal decides not to commission research and a research proposal is put forward by the claimants, which is deemed to be appropriate and relevant to this inquiry, if a direction is provided that clearly states that while the tribunal's resources are not able to commission the particular proposal, if it validates that research, if it's deemed to be appropriate, such a direction will assist in obtaining legal aid funding if that research is required after all of those steps have gone through. I note that His Honour Judge Clark has provided such a direction in the health inquiry, and more recently Judge Armstrong in the Macca Kaupapa inquiry as well. So just to move through the submission, we made just some preliminary submissions at the beginning of our submission on alternative relief research. We noted in the submissions that the pre-casebook discussion paper did not contemplate any of the recommended research undertaking an examination of possible relief. So it was just really to highlight this. We've seen in the stage 1 of the health inquiry that examination of overseas approaches to, in that inquiry, primary healthcare, and in particular looking at the Nuka model, which is a wraparound health service provided to the Indigenous population in Anchorage and Alaska, greatly assisted. In the housing inquiry, we have advocated for a similar approach, and so we were just really indicating that in the hopes that that could be included perhaps in some of the recommended research. Now, paragraph 6 of our submission, we set out the various recommendations. Our later submissions critiqued those recommendations, but I just want to draw out that at 6E, we submitted that perhaps the Crown, in relation to the statistics report, could provide indications on data it holds or could collate on 2 topics, the first being pre-1990 justice issues. At the moment, within the discussion paper, the pre-1990 justice issues are sitting within the second overview report, but we think if there would be sufficient data to validate a proper examination of those justice issues pre-1990, then perhaps the Contemporary Justice Project could be expanded in scope, or an alternative pre-1990 justice report be commissioned, or else that it's covered in the overview report, but I'll go to the issues with the overview report shortly. The second topic is whether there could be collated data on Crown interactions with Wahine Māori in the treaty settlement space, and that could go to the representation and leadership report, providing primary data, whereas at the moment I think Ms Walker is anticipating that that report would largely be based on secondary material. So if that were available, it would be most helpful. Just in the theme 1, the main submission there is that we think that it's not until after the tuapa hearings that we'd be able to provide full submissions on whether there is evidential coverage. Excuse me, ma'am. It may be that with the sources available and the evidence presented in those hearings that covers off the research that is required there. However, we can't assume anything at this point, so we would seek leave or an opportunity to present some submissions after the tuapa hearings on the evidential coverage of those historical elements in the first theme. The second point on the first theme is that the pre-case book discussion paper and the recommendations made don't necessarily match the claims put forward in the inquiry. So several of our claimants have alleged that the Crown failure to protect their inherent mana and rangatiratanga in relation to Mana Wahine role, status and knowledge from 1840 is until the present day. The first overview report is only from 1840 through to 1950, and then the second report from 1950 onwards is to be focused on equity issues and disparity issues. So it's not necessarily the case that that second report is going to catch the legacy or the implications of that loss of protection for all the issues that is within the first overview report. So it's just to highlight that in particular for our clients, we are concerned about the implications of the loss of property rights, and those implications could be touched on to some extent within the leadership and representation report, as the loss of property rights will go to some of the matter of influence and capability of Wahine Māori, but it doesn't mean that all of those issues will be captured by that report. And secondly, I think the other key issue for our claimants would be implications for kaitiaki status in the contemporary sense. So we just want to highlight that there may be some gaps there that may not be filled by the overview reports. So touching on the second theme, largely one of the issues that we highlighted, and I won't go through the detail that we provided in the submission. So in the second theme, the discussion paper highlights all the various disparity and equality issues that have been set out by the claimants. And then from that list, which is substantial, going from employment, health, maternal health support, the removal of tamariki Māori, state care, family court issues, as well as justice issues and education issues. But then the only specific report that is recommended is in relation to justice. And so we acknowledged in our submissions, and we saw the approach that Ms. Walker was taking in response to the scoping paper, where we set out that we wanted the claimants wished that the tribunal would take a very holistic approach to the 4 po that were identified for this inquiry. However, we don't see that having to do it as overview reports is necessarily the only way to achieve that. So we made reference to our experience in the Māori Military Veterans Kaupapa Inquiry, where 5 overview reports were commissioned, but each of those overview reports, the commissionees had an incredible task ahead of them. They had a huge scope of a time frame, but they also had a lot of issues to address, and in our view, it was an impossible task. I think I referenced Ms. Walker's report that she did in that inquiry, where she had from 1845 to the present day to look at health and social impacts for all of the conflicts, and it was just impossible for her to provide an in-depth analysis. So the point there is that we're concerned with the approach with the overview reports, that although the issues will be able to be placed side by side, it may lack the in-depth analysis that is required. And so our submission is that it's clear that there will be a need for further supplementary reports to add to that research. And in particular, we highlight, as I highlighted before, about the justice issues and the potential of having a pre-1990 justice issue. And all of those equality and disparity issues are deemed to be within that second overview report. But again, that overview report goes from 1950 to 1990, which means all of those equality and disparity issues have absolutely no coverage from 1990 onwards. So that's also a last gap. We provided some submissions on gap research that we could foresee. Those are at paragraphs 25 to 30 of our submissions. So those covered off particular issues that we have on behalf of our claimants in particular. I just want to make just a final additional submission, just in correspondence with one of the other claimant counsel this morning. We also have a claimant who is raising issues with issues around prostitution and the impacts, mental health impacts of historical prostitution. Now, Ms. Walker in her report also referred to the fact that there is some research and overlapping inquiries, for instance, the health inquiry, that may be able to assist in this inquiry. So just a note to say we've taken a look, and the Timothy Gasson report on mental health, which is currently in the Y2575 inquiry, does not touch on prostitution at all. That will be a further gap that we would see that needs to be filled. I just wanted to ask if I won't go into any more of our submissions unless there were any questions to be taken.
Yeah, I had a couple of questions.
Yeah.
The first was just in relation to your submission concerning research on alternative relief. At what stage of the inquiry do you think it would be appropriate for that research to be, if that was to be commissioned? Because it may be that as we progress from the tuapapa hearings, which may provide some focus on particular issues, and then into the substantive phase of the hearing, that different things may be accentuated, and other things may assume less prominence. So what I'm suggesting to you is that might be an issue of timing as well. Do you have a view on that?
Sorry, Your Honour. I don't have a view on timing. I think what your comments are completely accurate and correct. I think we're thinking of just that as the researchers are looking into these issues, they may at the same time, it may be a natural kind of outworking of that research and seeing how the particular issues that they're looking at have been addressed overseas, and there may be models, whether Indigenous models or general models of resolving these issues that may be of assistance, and just to be aware of that possibility.
Well, it may be that a literature review at the very least might be a useful, and then as the issues come into greater focus as we move through the inquiry, just to be able to commission something which is focused on what's in front of us. So the other question I just had was in relation to the submission you were making around the claims regarding prostitution and mental health, and I guess rather than a commissioned research report, another option for an issue of that nature, rather than historically in terms of contemporary, is for perhaps maybe claimant briefs, giving lived experience, and then to get those issues before us in that way. Do you have a view on that as an alternative?
That is an alternative. I think in addition to that, what might be quite useful is whether if there is a report that's undertaken looking at particularly mental health issues, if a component of that kind of evidence, I'm particularly thinking about expert evidence about the various types of post-traumatic stress disorder and the impact that could have, particularly on wahine, could be quite useful, and a component of that type of expert evidence could have a facet that looks at the types of trauma that wahine involved in prostitution might experience, and then how that might impact their lives as well, which that type of evidence I think would be very useful on top of claimant evidence of their lived experience.
Here we go. I think, if I understand, you're suggesting that the two more specialised reports are in too confined a time period? You want it to extend back further than 1990, is that right?
Yes, the Justice report. So Yeah, those two, they are specialised. So if there is data available,
yes,
to extend beyond that current time frame, and I don't know the answer to that question, then yes, we would support the extension of the scope for the justice report, the contemporary justice report. It may be possible to put that within the overview report, but then again, our comments about some of the insufficiencies or difficulties with an overview report covering the pre-1990 justice issues in depth.
All right, so you're seeing this as data-driven rather than you having a time frame that you would wish to cover?
Both. We represent claimants who are raising pre-1990 justice issues, so this is an important issue that they would like to see more research done in relation to that, but then that's tempered by our understanding that in order to properly undertake an examination of pre-1990 justice issues, data would be required. So it's really, if we can get an indication of whether the stats are there, then we could look at whether that should be expanded, and if not, then perhaps it's within the overview report for now, and then once we see a draft of that overview report, if we feel that further research is required, then we can deal with that.
More qualitative rather than quantitative when it comes to a number of justice issues, if that was required.
Yeah.
I would have thought.
Yeah.
All right, thank you.
Thank you. Did you want me to do anything on the Joint Research Committee at this point, or will we come back around for that? Look, I can do it later. You can.
I mean, it would avoid getting you back, I guess.
I don't
back
mind,
on,
I can walk.
on your feet. Okay. No, I think we'll just thank you, and
Thank
we'll
you.
just hear from others who have made submissions on this issue of the scope of the research. I'm going to jump around a little, and I'm going to ask Mr. Whenua to make some submissions now, because Mr. Whenua, you had also made a submission requesting additional commissioned research also to cover contemporary employment issues, so I think it would be useful for us to hear from you now. Kia ora.
Kia ora. Thank you, ma'am. The first point to note is that the proposed research by the Chief Historian doesn't specifically cover employment as a distinct set of issues and inequities facing wahine Māori within employment. The proposed research is to look specifically at leadership matters and the claims put forward on behalf of my claimants, the unions in particular, quite set out in quite a detailed way the fact that leadership is just one aspect really of the inequities that wahine Māori face in employment. They feel it's useful because the issues are so diverse and broad-ranging to perhaps look at if we look at, for example, the pay gap experienced by wahine Māori expressly as opposed to wahine generally, there are a number of drivers that go toward, that influence that pay gap, and leadership is one of them, but definitely not the only driver. So just by means that's covered in the Memorandum of Council, which I filed 3.1.285, that point. But just for the benefit of the tepu, if I can refer to the claim on behalf of Te Runanga or Ngā Kaimahi or Aotearoa, the Runanga of CTU's claim, it's 1.1.1. Just to give some insight into some of those issues that wahine Māori face in employment. They start with the fact that our government has as a significant employer itself, as the regulator for all employers, and also as a procurer and funder for a significant number of employers which specifically employ wahine Māori in the likes of whānau ora, for example, entities within the likes of kohanga reo, for example, and other education entities. So it's a three-pronged claim, which looks at the Crown's roles not only as an employer itself, but procurer and regulator of employers. They start with the fact that that procurement regime is in and of itself inequitable, and that Māori funders are funded significantly less than their non-Māori counterparts. And that goes towards, as I think is fair enough to say, is quite well known, for example, within kohanga reo, it's the starting point for many of our wahine Māori in employment, the pay gap that they experience. And on top of that, a point that has been fundamental to them bringing their claims within the Mana Wahine inquiry is a real concern that they have on the part of the omission and failure of the Crown to adequately monitor and assess these types of discriminatory practices, and therefore the flow-on effects, the social and cultural and economic effects that wahine Māori face as a result within their employment, and therefore the impact on the holistic well-being of wahine Māori. So just to give an indication to follow up with that particular example, in 2018, our government's performance with respect to the International Covenant on Economic, Social and Cultural Rights was assessed, and the United Nations Committee on Economic, Social and Cultural Rights observed then that it was concerned about the entrenched unconscious bias experienced by Māori negatively affecting our enjoyment of economic and social and cultural rights. And in 2018, at that time, had recommended that our government introduce a government-wide strategy to ensure that the nature and impact of unconscious bias is understood by governance bodies and employees at all levels, due to the significant detrimental impact that unconscious bias has on us as Māori and as wahine Māori in all areas of our life. It also recommended that our government ensure that the strategy takes on board public procurement procedures and was supported by comprehensive training and education, as well as effective monitoring mechanisms. So I give that quick glance, if you like, into some of the issues facing wahine Māori in employment, which extend well beyond just leadership matters and affect us in a holistic way, not just our economic, but also our social, cultural, and holistic well-being. Just by means of example, for the benefit of the ipu.
Thank you. Now,
Yeah.
just to clarify, Mr. Whenua, your submission is that in order for there to be coverage of this issue, sufficient coverage of this issue before the tribunal, that there should be an additional commissioned research report which covers these types of contemporary employment issues. You would have heard the submission we've just had from Ms. Ratten as well. Similar also in terms of contemporary issues. So that's rather than being added to the existing proposal for overview report. Is that what your submission is?
Well, the primary submission, because this is a submission which is being made in response to the Chief Historian's report, is that this should be an additional distinct set of work that should be commissioned by the tribunal for the purposes of fully responding to the claims brought within this inquiry. So first and foremost, the submission is that this should be a distinct report. Employment.
And what period of time do you submit would be the most relevant period for the research?
It is a tricky question and one which my claimants have grappled with in the course of this inquiry. And I think I did raise it initially when talking about a chronological approach to hearing claims within this inquiry. Employment has no necessary starting point and is ongoing and enduring. Certainly the initial unions were established very well near our early contact period around the 1840s. So it's not a strictly and only a contemporary issue. And much of the inequities that wahine Māori are now facing are rooted in omissions established by the Crown in the past. And one of those, as it is also expressed at paragraphs 25 to 28 of the CTU claim, which I've been giving you examples from this morning, is education. Education and the failure of the Crown to adequately prepare wahine Māori for higher paid employment. So it's an integrated system, which it's difficult to pinpoint a starting point in terms of a system and regime of omissions on the part of the Crown. And that's the position of my claimants. That really it's historic and is not improving.
So perhaps I'm trying to sort of put some context around that. I guess, you know, what would be the period of time we would be looking at, for instance, when there was entrenchment of Māori women in low-paid employment, for instance, post-war, when rapid urbanisation was taking place, for instance, or that you are looking in terms of the systemic omissions by the Crown at an earlier period of time?
Yeah, the claim is brought with respect to the systemic omissions, minor nor from the outset at an earlier period of time and building up as those omissions compound and are inherited by wahine Māori generation upon generation. Having said that, though, it may be that some of the reports that are proposed, those reports that are proposed by the chief historian with respect to those certain timeframes, capture some of these issues, and it may be that we get to make submissions on what should be included or highlighted within those, and then have a specific employment related report which looks uniquely at employment as a theme. Your Honour, I could seek instructions from my clients as to where they feel the most useful starting point would be if we were to look at the most useful time frame for such a report.
Yeah, I think that would be useful. Thank you, if you were able to do that.
Thank you.
Does that conclude your submission?
Just one final point, ma'am. Although Your Honour, I acknowledge, has not yet granted leave for those who filed claims seeking to participate in this inquiry in the most recent tranche, I did file on behalf of Francis McLaughlin, representing the New Zealand Mongrel Mob, Wahine Māori Association and their families, and in particular Paula Ormsby and Cherie Kurirangi, representing the Wahine Toa, newly formed all-female membership. It's the all-female chapter, of the New Zealand mongrel mob. And so just wanted to make on their behalf, although they haven't been granted leave to participate, the point that also the proposed research doesn't cover the impacts of discrimination on women in gangs in New Zealand. And that's a big one from their perspective, because it is women in gangs who tend to feel the discriminatory impacts of Crown acts and omissions in the most heightened sense. When we look at other matters that have been raised by my claimant Y1511 with respect to inequitable harm, serious harm, sometimes resulting in death, facing wahine Māori as a result of violence, and particularly violence experienced by intimate partner relationships, then again, women in gangs are at the acute end of that. And so on their behalf, although they haven't been granted leave, I did seek in my most recent memorandum of council that be a consideration also for research. And I know that my friend Miss Sykes is also representing wahine Māori in gangs, although I'm not sure if she's made such a submission herself.
Thank you, Mr. Whenua. I mean, obviously, the issue of eligibility and participation is a piece of work that we are wanting to move on with as quickly as we can to get those issues finalised. And we will be discussing that some more later on in the conference. I'll just check if there are any questions from the panel. Okay, thank you, Mr. Whenua. Now, I just want to ask, I think it was Mr. Stone and Ms. Leunga, you also had a submission which was around additional report on contemporary economic issues. It seemed to be a slightly broader submission than a focus on employment. So I'll give you an opportunity just to make a submission now on that.
Yes, so those submissions are contained in Memorandum of Council 3.1.283. And so they do go a bit further and don't just focus on employment, but focus on the economic position of wahine Māori as a whole. So these claimants in particular are seeking for a separate report to look into the issues of financial support and economics around wahine Māori. So looking at specifically the contribution in the labour market, as well as improving the lives of women on low incomes. And they've also suggested that financial security as well as traditional low-paid work be included as specific research topics.
That's a fairly general submission. So in terms of us making an assessment, do you really think that that requires a separate report, or do you think that that is a matter which could be, those are matters which could be dealt with by expanding what is proposed in the case?
The claimant, these particular claimants did want a separate report specifically, but depending on the overview report, some of those issues could potentially be expanded upon in the second overview report. But these claimants in particular were seeking an additional more specific report for those issues.
Okay.
Taking into account as well things such as gambling and the impact that has on the financial stability of wahine Māori and their whānau.
Okay. Thank you, Ms. Leunga.
Thank you, ma'am.
Right, now I'm just going to move now to more general submissions that any parties may wish to make or highlight in terms of their written submissions in relation to the proposed casebook. Ms Mason, did you have anything at all? I'm not sure you filed written submissions, did you?
No, thanks.
No.
We don't have any submissions.
All right, thank you. Ms Loder, was there anything from you?
No specific submissions, but would like to support the submissions made by Ms Rawton.
Okay, thank
particularly around women in prostitution, as that's one of the main claims that we represent.
Okay, thank you. Ms Hall.
Thank you, Tribunal. Good morning. Okay, magic. The council thinks that Ms Walker's exploratory scoping report is an excellent beginning to this inquiry, and the three areas that she's identified being protection of the role and status and knowledge of wahine Māori, the equity and disparities with outcomes and well-being from wahine Māori, and representation and access to leadership, governance and decision-making roles for wahine Māori. So we agree with that position. We then go on to say we've worked very closely with two experts in women's issues, beginning with comments from Professor Wilson, which we sent in advance, but I'll just summarise them here. She's advised the Council that the issue in the Mana Wahine claim, in her view, is the loss of rightful status and Mana Wahine as a matter of whakapapa and therefore of right in a pre-settlement Māori society. She goes on to say, importantly, research points to consider should be white feminist ideologies that have had an influence in informing policy and practice and the negative impacts of that on wahine Māori. The second is the disrupted masculinity of Māori men and its impacts on the mana and well-being of wahine Māori, aided in part by their cultural, social and economic disenfranchisement and hegemonic patriarchy. The third comment is interpersonal and institutional racism and discrimination on marginalising and excluding wahine Māori socially and systemically, and the systemic exclusion of wahine Māori from the historical records relating to the settlement of Aotearoa. And she says that's best translated, if you look at tangata to mean men, it's something that persists right through to today. It's her view that these topics are mentioned in the scoping report or can be addressed under the three themes and in the two overview reports, and that if we set them out, then they can be factored into the general outline. So fairly large tick to just proceed as been proposed from Professor Wilson, from Dr. Hagar, our second expert. Dr. Hagar has advised that the idea of hegemonic masculinity is not covered in the scoping report. Hegemonic masculinity is a dominant worldview. Hegemonic masculinity is the idea that men, and everything that relates to men, is more important and valued than things that relate to women. And this idea is visible in various ways. So we have heard an excellent outline of this from Ms. Tania Tawhina. Women's work is not valued and remunerated as men's work is. much of women's caring and domestic work is not paid for or valued accordingly. Child raising and nurturing is seen as women's work and undervalued. Industries that primarily employ women are the lowest paid, and then wages are further reduced based on race. So there is a lot of symbiotic agreements running with the sorts of arguments that were brought in by Ms. Te Whenua. I'd like to go on just to say that I struggled to explain what the term hegemonic masculinity meant when I would talk with the groups of women around the country. Their eyes would go like this, and mine would follow them. It's inherently a really difficult concept to explain. So then we just broke it back to saying, have you ever wondered why it is that only men speak on the marae? Who made that rule, and when was it made? And what was the thinking behind it? Why is it that Māori women sit on the floor of the marae or at the back? How did we end up there? When were those decisions made, and what was the thinking behind it? I sit now on the Te Puia board, and I deliberately put myself onto the cultural committee of the Te Puia board. And I announced that I thought I was a very good person to sit on that particular committee because we could start planning now for the day when Māori women will graduate from that art school as tohunga carvers. Never been done. So what is it? What is it that cuts Māori women out from all of this type of status? Why is it that we don't go into whare where carvings are still half completed? So when you explain the term hegemonic masculinity and put it in that framework, everyone knows straight away what you're talking about. So we do say that hegemonic masculinity, and there is also hegemonic femininity to be factored in as well. How they're worked in, because the topics have been well set out in our opinion by Ms. Walker, they can be, but with this topic, which has a really close link between cultural understandings and where women have a set framework, when it gets that close, you've got to be a little bit careful about how we come at it. And perhaps that topic needs some very special attention given to it. And the Council thinks that there must be other cultures around the world that have had to face this. And that perhaps we should look at taking some advice from other cultures and seeing what they've had to do when you run right into the interface of existing cultural norms now on the marae and what we would describe as being hegemonic masculinity. And so we'll just leave it there for discussion.
It occurs to me that it might be very useful for some of those matters to be discussed and for us to hear views and evidence about that in the tuapapa hearings. And then perhaps after we've been through that process, then we can maybe refine the type of evidence, the type of research that we would perhaps require, as we move further into the inquiry process. But it just occurs to me that those areas would be very appropriate, I think, for the tuapapi hearings, and I'm seeing my colleagues' head nodding here on my left.
Very good time to let Mount Taranaki go into the front, and this is one of them, because it is such a contentious issue. But let's just put one of the big elephants on the floor and in the room, right up front, at the start. This does need to be addressed. Now, if I can just close by saying, Mum, that I am a trustee on Makoia Island, and I've been on it now for longer than I care to mention. And I went on as the only woman, and certainly the only one under 100 some years ago. And in that particular trust, where 4 hapu of Te Arawa do the appointing, and then I arrive, the whole way things are done sets that they continue to be done is very prevalent right through the Māori world. And it does take time to introduce changes. Now, all I suggested is, as there's 4 hapu, maybe we could look every 3 years at moving the chairmanship from one hapu to another. Well, that took me 15 years to get through. And all what I want to say is sometimes you've got to put the position on the table and plan for the long haul.
Now, Ms. Hauraki, did you want to make any submissions on this casebook?
Actually, I've got a couple of points, if that's all right. We didn't file a written submission.
Yes, I understand.
But first would be that, I guess from my client's point of view, if and when the joint research committee is convened, it would be useful for that committee to consider and potentially provide feedback on the report. I think the discussion so far is to have a number of experts on that committee, and they may be able to provide further insights. The second point would be that my clients would definitely be supportive of research into relief, and they've done some preliminary thinking around that, but I think they would agree that it's likely to come into focus as the inquiry progresses, so it will be a matter of timing. I think from my experience on the health inquiry, it would be useful for that to come in advance of, relatively well in advance of closing, because in that inquiry we sort of ended up in a situation where there were lots of sort of really good ideas that were not well fleshed out, and the flow-on effect is that a lot of that is being developed subsequent to the inquiry closing on the stage 1 issues, and the tribunal wasn't able to feed into that process so much. So it would be useful, I think, to have more of that discussion prior to the issues being closed on. But those are all. That's my submission.
Thank you, Ms. Hauraki. And just picking up on the first point that you made about the research committee having an opportunity to give some feedback. I mean, obviously that is contingent upon us getting to a point where we can confirm, the participants in the inquiry, so then the process for appointing the membership of that committee can take place, so that the committee is then in a position to do that mahi. So I'm aware that there are a number of matters that need to fall into place before we are in a position for that to happen, but certainly I would be supportive of that. Now, I think Ms. Ms Doty Ware, did you want to make any submissions? I'm aware that you haven't filed a written submission on this topic. Were there any oral submissions you wanted to make? Casebook?
Kia ora, is that on? Yep. Ka pai, no oral submissions at this time other than what has been put forth by Ms Rawton this morning.
Thank you. Now, Ms Herawini, are you there? Did you want to make any submissions on behalf of your clients on the casebook? I think there was a reasonably substantive written submission that was filed.
Tēnā koe, ma'am.
Just to highlight.
Kia ora. Nothing further to add, just in terms of the joint submission as well that was filed by Tamaki Legal Document 3.1.280. I just wanted to record our support for that joint memorandum. And in terms of submissions for our Miss Verity Cross, the submissions that we filed on 30th of September, and that's document 3.1.287, they did only intend to be preliminary, as you would be aware of the collaborative approach that we're taking with the other 381 claimants as well. So I'm cognizant of that fact and would like to the opportunity to discuss this further with counsel for 381 claimants and to possibly submit something, a collaborative or a joint approach to the scoping report. In respect of one of the key issues for the Māori Women's Welfare League was just in relation to the theme 3 of representation and access to leadership and governance. There's nothing in terms of additional research, commission research that we are proposing, other than to ensure that there is coverage across from the periods of 1840 to today. I know with the overview, the second overview report, that goes to 2000, sorry. And then the contemporary suggested commission report on representation and leadership goes to from 1990 to 2018. So ensuring that there is coverage from 1840 to today would be our key focus. But also just supporting the submissions of Ms Hodaki on the joint, the benefit that will come from hearing from the joint research committee as well. But if those would be our submissions on there. They're only preliminary, and we would seek the opportunity following any comments from the research committee or further kōrero with the 381 claimants and council providing further submissions on that. Tēnā koe, ma'am.
Yeah. Now, were there any other claimant counsel who specifically wanted to make submissions on the issue of the casebook? Dr. Gilling?
Thank you, ma'am. Just a couple of comments. We didn't file any written submissions, as you'll be aware, but we are in support of the Tāmaki Legal Document 3.1.288, which was what Ms Roughton spoke to earlier. Regarding particularly just a couple of points, maybe three, we would indeed support this, the idea of some additional research regarding varieties of relief that might possibly be available. This is something that we've identified with clients in the kaupapa inquiries already as to what can possibly be done, as opposed to, for example, returning land or forests or those sorts of things which are particular to district inquiries. So imaginative approaches are going to be needed. And your suggestion, Mum, with respect of a literature review would be a great start. The other query I had about that was that we might need to be looking to commission people other than the people who normally work in this field, because with all due respect, most of them are New Zealand specialists and don't necessarily have any ready access to some of the ideas and schemes and so on, as I mentioned in Ms. Roughton's memo at paragraph 5. And for efficiency and also breadth of coverage, we may need to look further afield than that. And in terms of timing, question you raised, I think, Ma'am, we think it would be appropriate to commission after the tuapapa hearings, when we already are starting to get a collective feel for the breadth of the issues and the feelings that people have about them. And in terms of the length of the project, we'd respectfully support Ms. Haureki's submissions about getting them available before we have to do closings. That would be, I think, particularly helpful both to Council and hopefully to the Tribunal when we are providing those submissions. Two other things, Ma'am. I support Ms. Roughton's concern about the possible lack of depth in the overview reports, particularly the second one. There's just so much to cram in to those, and it would be better to try and work through that up front and make the detail available as soon as possible, rather than to have lots of gap filling, plugging things as they come up later on. So detailed project with plenty of time. And Ms. Te Whenua's submissions about employment issues as a topic, we would also support one of our claims, Y2922, has a special focus on women in the shearing industry. And that's in some ways a bit of a niche interest, but it raises a number of the matters that Ms. Te Whenua has already made submissions on. In terms of how far to take that back, well, unions only start to become a thing in New Zealand in the 1880s, 1890s. Labour Party is formed, I think, 1912, after a bunch of miners' strikes and the like. So the employment matters may be difficult to get a grip on back in the 19th century, beyond the information that the tuapapa hearings may provide about the traditional role and work of wahine Māori. And therefore, our thought was maybe to best begin with World War II. When you have an upheaval in society generally, women are being brought into the workforce in large numbers, and some of them would be Māori, whether they be land girls, or as they were called, or brought into factories, industrialisation activities. Then you have, that after that upheaval, a huge change again as the men come home and try to resume normal transmission. And so that would already have a bunch of existing research on it, which could give a useful start. And it's perhaps the time when Māori society is suffering biggest upheaval with urbanisation, people moving away from their tūranga waiwai into cities and the need for cash jobs and employment. So, Ma'am, those were just my submissions and comments. Thank you, Ma'am.
Thank you, Dr. Gilling. So I'm just aware that we will be breaking for lunch in about a quarter of an hour, and I want to give the Crown an opportunity to respond. So before we turn to the Crown, are there any other claimant counsel who want to make any submissions on this issue of casebook? And that is Mr. McGee.
Yes, ma'am, just a brief submission.
Yes, brief would be great, thank you.
Right. We support the proposed reports in the discussion book on the casebook, especially the contemporary reports, notably the contemporary justice issues. We would think it's really important that that is right up to date, especially incarceration. Recently there's been some important Court of Appeal decisions, I think, that says there's discounts of up to 15-20% for cultural reasons. So these reports under Section 27 of the Sentencing Act have become quite important and have a big impact on sentencing. So just to take those into consideration, and also under the Sentencing Act there's scope for an alternative justice process which can affect sentencing, and that could be a Marai-based process, and it just be, I think, relevant to see just how much or how many or how involved the Marai have got into that option, because that could really affect sentencing for Maori women. So it's just those two issues, the Section 27 reports and the alternative justice process which can affect the sentencing. Those two issues, ma'am.
Thank you, Mr. McGee. We've noted those. Now I'm going to ask the Crown. They have some submissions on.
Kia ora, ma'am. It's Tupara.
Sorry. Oh, Mr.
You might be able
Tupara,
to
you've
see me
popped
on
up.
Zoom, hopefully. Yes, I have arrived, and my apologies. I understand Ms. Thompson indicated that myself and Mr. Hirschfeld will be able to make part of the day. Just want to respond to the submissions made by my learned friend earlier this morning regarding some hegemony issues.
Right. Before you do, Ms. Thompson's already made submissions on behalf of yourself and your clients. So, I mean, okay, I'm willing to hear from you if it's brief, because I'm just aware of our timetable this morning, and I'm just wanting to move things to the Crown as quickly as you can. So, briefly, Mr. Tupara.
Yes, just a few seconds to support your thoughts and proposition that there needs to be research and also evidence on the role of Māori women. There is a claim before the tribunal in this inquiry which addresses the failure on the part of the Crown to ensure that Māori girls and women were provided with or taught mātauranga Māori, particularly from a Māori woman's perspective. And many of the questions that are raised about the role of men and women, particularly on the marae, are answered in that evidence. And I would support that being brought forward in due course. Thank you, ma'am.
Thank you, Mr. Tupara. Ms. Teron.
Tēnā koe. Your Honour, we don't have any comments of substance on the report, but perhaps it would be useful to provide a brief update on the Crown Statistics Project. We stated in our memo that the Crown would get in touch with tribunal researchers to discuss that project to get a better idea of the scope of it, and there was an initial meeting with officials from Stats and the Joint Ropu, and the upshot of that meeting is that further discussions are needed once, in light of the claimant submissions on the report, and that it would probably be appropriate for those discussions to happen in the context of the research committee going forward. So the idea at this stage is to move those discussions into the research committee once it's formed. It sounds like there will be the definition around the research that will be commissioned is going to develop over time and perhaps only really come into focus after the Tuapapa hearings. But hopefully we'll be able to get some work on that project underway in parallel, and we'll just have to work that out as we go.
Yes, that would be my hope, that the issue around what is going to be commissioned can be resolved fairly early on in the first quarter of next year, and so that the research can proceed during the course of the year while we are working our way through the Tuapapa hearing program. So ideally to have those matters going in parallel so that we're using the time that we're focused on Tuapapa to be also getting underway with getting that research so it's available when we come to the start of the next stage of the hearings process. So we're not going to have too much of a time lag there. So that's the ideal situation.
Thank you, and I have no further submissions.
Well, we have another 10 minutes or so before we break for lunch, so we may as well make a start then on talking about the Research Committee. And what I am interested in hearing from somebody, it might be you, Ms. Rart, and I'm not sure, or Ms. Hauraki, is the submissions referred to some further discussions to take place amongst Claimant Council in relation to the way in which membership would be determined and whether or not there's been able to be any agreement on that, or whether we're still in a position where we have a couple of ideas.
Thank you, Ma'am. Yes, so I can update you on that. So we, Claimant Council, held a talihui as noted in the joint submission. We also held an additional talihui last Thursday to try and reach a little bit more agreement on the issue. So the main issue that we're facing at the moment pertains to the nomination process for the claimant representatives and the Claimant Council representatives. So within the terms of reference, that nomination process was left to be decided by the claimants for that group of representatives, as it was for the tribunal and for the Crown Council to decide how they were going to appoint their people onto the committee. So there's essentially, unfortunately, we haven't reached any further consensus. So the two positions are the current positions. So just to summarise those, although there is a slight alteration now because of the developments with COVID. So the two positions are firstly, and there's two questions that go into these two positions. The firstly is what is the nomination process going to be for claimant representatives, Claimant Council representatives, and secondly, and related to that, who can vote for the claimant representatives.
Could you just remind me, what is the proposed size, membership size of the committee?
Up to, I believe, if my math is right, 11 members total, up to 7 claimant representatives. Then there would be 2 Claimant Council representatives from the wider claimant community, 1 Claimant Council representative from the Y381 Rupu, 1 from the tribunal, and 2 from the Crown, 1 being Crown Council and 1 being a member from the joint Rupu. I hope that comes up to 11 or 12. Yeah. Oh, 13. Sorry. Yeah.
So you were just explaining just the components of the position, the decisions.
Yes. So The first position, which is largely accepted by most claimant counsel, is firstly that only claimants would vote, and this underpinning that is the belief that the work of the research committee is more mahi driven rather than mana driven, and so the work of the Joint Research Committee in relation to the research being put forward in this inquiry is going to benefit the claimants and be able to support the claimants' claims in this inquiry. So therefore, linked in with that is that the claimants would be able to vote for that, for who was going to go to represent them on the committee. So
when you say claimants, do you mean named claimants, or do you mean the group who sit, whatever ropu sit behind a named claimant?
We haven't
we are limited somewhat by the conventions of the tribunal and how claims are filed, obviously.
The question of how many votes a claimant group would have has been raised, but we haven't answered that question. We've kind of gone to the key question of whether it's claimants alone, and on the other side, which I'll touch on later, is all wahine Māori, whether it's extended out to all Māori voting on who's going to represent on the committee. That's the other side of the position. So just going back to the claimant side, so that process is general agreement that then the claimants, if it was deemed that the claimants vote, they would provide their votes or nomination of the claimant representatives, claimant council representatives. They could do that to their claimant council. That could then be collated and a list agreed in quite a short period of time that could be done. Now, the other view is supported by the New Zealand Māori Council and put forward by Woodward Law, and that is that because the work of the committee is likely to impact further than the claimants, that the view is that all wahine and actually in the context of a national hui that would be convened, then all those attending the hui, whether they're wahine or not, could vote in that. Now, initially, we were talking about regional hui being held, and that was put in the joint memorandum of council, but due to COVID restrictions lifting, it might be possible to do that in the form of a national hui. I think there is, at the Tele Hui last week, we talked about the possibility of a national hui, and in addition to that, also having online voting process for those claimants not able to attend. But again, we did come to an impasse, and that's this key aspect of who should be able to vote that we cannot reach agreement on. And so therefore we're bringing it before you, Your Honour, to seek a direction or assistance in resolving this. And I believe that some of the other claimant council may want to make further submissions on this point.
As I understand it, there hasn't been any agreement being able to reach on that particular issue. So in a moment I'll ask Ms Hall whether she wants to make any submissions on the position that the New Zealand Māori Council wishes to make. And I also want to hear from Council, I think Mr Tinahu. You know, you and your claimants have expressed a view on the membership of the Crown on the research committee, and I think possibly Mr Whenua might have also expressed a view. So, you know, there'll be an opportunity for you to just to highlight what your submissions are there. So, so I do understand that position around that you've outlined for us in relation to the research committee. Yep.
Oh, a couple of other matters.
So just let me clarify before you do.
Yes.
But you are in support of the Crown's membership of the committee, the joint.
The current joint
yes
position
yes.
Is that we have already agreed
yep.
through the terms of reference
okay.
for that. Now that kind of touches into something that arose at the Talihui last week, which I wanted to draw to your attention, because the Crown's membership on the committee has been agreed, but in the last Crown memorandum that was filed, there were some submissions on a shared research agenda. And so as a result of that memorandum, there is some uncertainty around the relationship between the Joint Research Committee and the shared research agenda, which may have an impact on the claimant's view on the Crown membership on the Joint Research Committee. So I just wanted to request that perhaps the Crown could provide some clarification today on the relationship between the shared research agenda and the Joint Research Committee, just to resolve that issue of uncertainty there. And just two other matters that I had prepared, which we had in our joint memorandum of council, which we've already noted that we're unable to move forward on the nominations until that final list of claims is distributed by the tribunal. And then also the last matter is the issue of a conflict protocol. This arose because, as noted by my learned friend Ms. Hauraki, that many of the claimants are of the view that the claimant representatives on the committee should include experienced researchers or academics to bring their experience and their knowledge to the committee. But in doing so, that may create a situation where if one of those researchers or academics wants one of the commissions, is that a conflict of interest there, and can we resolve it through a protocol? So this has been the subject of some discussion amongst Claimant Council. A protocol has been drafted and we're still having discussions about that. We've sought the views of the Crown also on that. So we'll keep you updated as to how that progresses.
So, I mean, the tribunal has some protocols around this as well, and also there are some expert witness guidelines, I understand, in terms of the High Court as well. So there are various sources that can be sort of drawn on to reach what it would be a final position. But certainly at first blush, there appears to be an awkward situation to have, the expertise sitting around the table, but also wanting to be involved in commission research. So that's going to have to be resolved, quickly.
Yes.
Okay.
So those were the
Thank you.
submissions. Thank you.
Thank you. Well, I think that brings us to lunch break. After we go to break for 1 hour for lunch, and then when we come back, I would like to hear from Ms. Hall, just in relation to that membership issue, and then there will be an opportunity, Mr. Tinahu, you'll have an opportunity just to highlight the submission that you've made, and if there are any other claimant counsel who particularly want to be heard on this. But otherwise, if we can move quickly through this particular issue, and then we'll be needing to be talking about funding.
Judge, just before, if I can just comment to that, the council is quite keen to hear from all of its accusers before it has to put a response. If you wouldn't mind, we'd like to hear what anyone who agrees with Ms. Roughton has to say, and then we'll respond.
All right.
Thank you.
Okay. Thank you. Well, we're going to break for lunch now. So we are adjourned, and we will resume again at 2:00. Kia ora. Parikai.
20% protein for muscle development, Nutri-Grain is one of the highest protein cereals. It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
always wanted to live in this neighborhood. It's a happy, cheerful place.
I just wanted to buy a house close to the ocean. It was hard to find that.
There's still the aura that there's something here.
This is where the bodies were buried.
Yeah. There was 7 bodies total.
Oh, wow.
This man killed his wife right here where my husband is sitting.
It's almost impossible to believe what happened here.
This is where all the murders took place.
Correct.
To afford to live by the beach, we had to buy a house where a guy chopped his wife up.
Murder and makeover don't usually go together.
But this isn't just about design. We need to give this space new life and energy.
Are you trying to tell me that we'll find body parts?
It's a distinct possibility, yeah.
You took a shower where he dismembered her.
The murder weapon has never been found.
Come take a look at this.
Wait, do you see anything?
Typically, I would say ladies first, but you're not gonna leave me upstairs.
Are you searching for a natural deodorant that works? Discover Schmidt's. Made with 100% natural ingredients, including coconut oil and shea butter, Schmidt's keeps you fresh all day naturally. Schmidt's, a natural deodorant that works.
It's YouTube Music. Download the app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply. Have you heard about the new music streaming app made by YouTube? It's built for listening with the hottest songs and albums and, of course, all of your old favorites. Download the YouTube Music app today and get a trial of Music Premium on us. Limited eligibility, restrictions apply.
Tēnā tātou. Now, we just heard from Miss Rowton. Do we hear from somebody else after you? Sorry, my recall. Mr. Gilly. Dr. Gilly.
Thank you, Mum. This is just to let you know on behalf of Miss Curtis. She had another fixture at the District Court at 2:30, so she's gone off there. She may or may not be back, but she asked me to seek your leave to withdraw.
Okay, leave is granted, of course.
Thank you, Mum.
Yeah. Now, we were discussing the issue of the membership of the Research Committee, and as I understand it, Ms Rowton was describing where matters have got to, and in the position of number of council in relation to the way in which those claimants would be chosen. And Ms Hall, now's an opportunity for you to just to talk to us about how you see that issue. Thank you.
So there is a difference of opinion from the New Zealand Māori Council on the process of appointments to the Research Committee. The Council submits that the Research Committee should be nominated by Māori women at a national hui run by Māori women for Māori women, and preferably in the Māori language. Māori Council does not agree to Legal Council being the majority of appointments or to Legal Council making the appointments. And the argument is that while any Māori woman can bring a claim to the tribunal, it does not follow that that Māori woman particularly, or that Māori woman's legal counsel, have the capacity to determine the adequacy of research for the Research Committee, or the right to do so, when the policies and practices and the outcomes of this inquiry will affect all Māori women. And when there are Māori women in the field with a considerable experience in the area and who are not claimants, and we refer there specifically to Professor Denise Wilson as a perfect example. So there's a large contingent here today who say the claim is just for their clients. Only claimants and only our clients can have a say. And the council's position would be, that's quite Pākehā thinking, and that the claim is for all Māori women, all women, Māori women. We question the legitimacy of a process where only claimants can talk or make decisions. We ask, what is the legitimacy of an inquiry based on that narrow a framework? The claims are brought claiming prejudice of all nature against all Māori women. So we say you can't have a mandate to represent Māori women if Māori women haven't put you there, if they haven't selected you, giving you the right to stand and speak on their behalf, or through an organisation, a national Māori organisation, and all the way through the council has supported the League should lead. The Māori Women's Welfare League over 50 years has advocated policy for the betterment of the well-being of Māori women, so that organisation can claim a mandate. The Maori Council can claim that mandate. But we challenge that lawyers in this room can similarly claim such a mandate. We just straight challenge it. Lawyers here only have the mandate, in our view, to represent the interests of the clients who appoint them. And that's as narrow as it is. So we have a theoretical basis for our position. This is something very important to the Council, and it comes from the United Nations and its Declaration on the Rights of Indigenous People from UNDRIP. Council was pretty pivotal in getting UNDRIP through. Over 25 years of attendances to Geneva to get UNDRIP's principles locked in. So we submit that UNDRIP is an important source of principle for this tribunal here. And we say it gives expression to the inherent rights that were latent at the time of the treaty. And the articles relevant to the current issues we say are Article 18. Indigenous peoples have the right to participate in decision-making in matters that would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous making institutions. Article 21, Indigenous peoples have the right without discrimination to the improvement of their economic and social conditions, including in the areas of education, employment, vocational training and retraining, housing, sanitisation, health and social security. And at Article 23, Indigenous peoples have the right to determine and develop priorities and strategies for exercising their right to development. In particular, Indigenous peoples have the right to be actively involved in developing and determining health, housing and other economic and social programs affecting them as far as possible, and to administer such programming through their own institutions. So the Council questions an assumption that having a majority vote from legal counsel for a majority of claims means representing the majority of claimants in this inquiry, or for that matter, the majority of Māori women. Several claimant counsel have at various times said that they represent all Māori women. We challenge that. And we do go on to say, ma'am, that the national hui was ruled out by COVID when it first came up, but that's all gone now. And so as one alternative, the Council has just recently, Ms. Broughton referred to it, received a proposal. The Māori Council would be willing to assist in the hosting of a national hui out of South Auckland or Rotorua or Wellington in the last weekend of November of this year. If that for practical reasons cannot be done, and I'm told there's a lot of clashing of timetables, we at least want it on the table that we've put that alternative there. A second option that we put for sorting out the appointments to the research committee was that the national organisations that have proven track records for developing policy should nominate the 7 members, and we did propose that the League, the 381 claimant group is in 4 parts. They should each nominate 1 person. The Council would see itself as nominating 1. And there are 2 contingents of nurses that spread the whole country, nurses organisations. If each of them put in 1, you get 7. That's another option we put forward to resolve the impasse. And I do want to say, because we have run into a a block each time. And the council can see that there's a very strong team running to say, well, one council, one vote. The Maori Council now says, don't go, we're saying don't go to that option. We would prefer, and we put it right here, that if there cannot be agreement on how this very important committee is appointed, then don't appoint a committee. You make the decision yourselves. Hear from all of the lawyers in the room, including the Māori Council, and you commission the research. And we do ask that to be looked at because this is no ordinary committee. It's been described variously in the past 3 months as, oh, a committee just to get the researchers together and the researchers will make the decisions. Oh, it's just a committee to talk to the others and send out a direction on which way we're going to go. I have attended and read all papers. This committee is the brain cell of this claim. Whatever research is commissioned is going to be the driver to the way the claim is going to be run. So this is no ordinary committee to decide on any ordinary research program. It is the committee that will finalise what is going to be put in place as the overarching research projects, the detail of them, how they're going to be carried out, and how a scarce amount of funding is going to be allocated. This is no ordinary committee, and we will not have it treated as such. So we say, if we can't get agreement, then we should be entitled to put our submissions to you, and that you could hear from all others, and then you make the decision, and we will accept that decision and work with it. And that is our reply.
Kia ora. Just, I mean, by way of observation, obviously the kaupapa inquiry program is a new program, and the tribunal was looking at new ways to approach how research is commissioned. So clearly this type of issue isn't going to be confined to this inquiry. It's one which potentially could come up every time there is a kaupapa inquiry that is going to be commissioning a significant body of research to be done. So, I mean, obviously it's a matter that we want to take some time to understand the positions of the parties and then to give as many opportunities to come to an agreed position as possible, but then if that is not possible, then, you know, that decision is ours to make as to how we move forward with that. So I'm very clear about that. And it seems to me we have reached that position, haven't we, where there doesn't appear to be a prospect that that is going to shift those positions. So certainly in terms of where we get to at the end of the hearing, there will be further memorandum directions in relation to written submissions, opportunity for written submissions, so that matter can then come to us. Okay.
Just matter, it certainly isn't through lack of effort on the part of Miss Roughton that we haven't got there. She deserves a Medal of Valour.
Okay, thank you. So we have had that discussion about that issue of membership of the research committee, and I just want to give an opportunity, Mr. Tanahu, if you wanted to, just highlight any key submissions that you made, but certainly you had raised some issues in relation to the Crown's membership, and the Crown has given a response in writing to that, and you have again confirmed in writing your client's position. Is there anything, key submissions at this point you wanted to highlight?
Not besides, thank you, Ma'am, but not besides what we've put in writing. We just want to reinforce that we still oppose the Crown being a member of the research committee. based on the reasons that we set out in the memorandum.
Okay.
But in terms of the process and the makeup of it, as discussed by Ms. Hall, there is, and what we have discussed in our Zoom huis that we've had, my clients that I represent, Ngā Hapu o Kereru, which make up Ngāti Takiaku, Ngāti Ngarongo, Ngāti Hinimata, they're very clear that this could be also a simple process, not as complex as what could be interpreted to be. We've suggested that the 7 members of the research committee be nominated by the claimants, that those nominees are downloaded and they are distributed to all the claimant community, and they are given an opportunity to vote from 1 to 7 on those names who are nominated. And as a consequence of that, what we did discuss was, for example, if you've got 3 hapu under Ngā Hapu o Kereru, what's the process of nominating that? Are we talking about one nominee for that particular wine number, or are we talking one nominee from each of the hapu? Those are the kinds of things that we were discussing, which could be a problem, which we can confirm was part of the impasse that we had. But in terms of the makeup, we did not see it as complex as Ms. Hall has, where you have a national hui, etc. The claimants that I represent were quite concerned that when you have those kinds of processes, they're attended by those who answer the call. And there's not necessarily a guarantee that those who do attend are actually claimants in this inquiry, but they may have a position, maybe put in a position where they can actually make a determination. And those are the concerns that my clients had. Hence the reasons why they suggested it be quite a simple process. And the other thing was the costings of it. We've only got a $400,000 research budget, which we all have to fight for. And it's, it's going to be an issue for that. And how is that going to be met when we thought that the simplest way, everyone put in a nominee and vote on that. Those are the submissions on that, Your Honour. There's nothing that we have wished to add in terms of the reason why we oppose the Crown. So
it's clearly set out in your submissions. Thank you.
Thank you, ma'am.
Yeah. Were there any other submissions on the Joint Research Committee before we move on to funding?
Sorry.
Ms. Mason.
Yes, I would like to make a few submissions. Firstly, we are supportive of the position put forward by Mr. Tanahu and by Ms. Raughton that it should be the claimants who have a vote. There are some legal issues around the tribunal's jurisdiction in that this inquiry is based on the claims before it. And so, therefore, it should be the claimants who determine what research is put forward in conjunction, of course, with the tribunal. And the other issue, ma'am, is that this is a legal process, not a political process. And any discussion about mandate doesn't sit well with this inquiry and with this process. And then there is the practical problems that arise with that suggestion. It's just beyond me how people are going to measure and ascertain who all Māori are. And there are many Māori women who wouldn't be attending those hearings or those hui and would be left out, especially those who are marginalised. And, ma'am, I think there are something like in excess of 200 claims in this inquiry. That's a very representative group of Māori women. There are nurses represented, there are gangs represented, there are women's refuge, there's a huge range, and collectively those people together should cover everything. And so the suggestions by Mr. Tanahu and Ms. Raughton that those claimants decide themselves, and of course those preferences would be put through via their council. And it's not a committee of council, it's council representing all of these claimants. So I just wanted to add that,
Thank you, Ms Mason. I mean, it seems to me we've probably got as far as we can get to in terms of submissions. You know, clearly we've reached, council have reached an impasse, and there needs to be a process for an opportunity for written submissions for that matter to come to the tribunal now. So, Crown wanted to make any comments or?
Yes, Your Honour. Perhaps if I can just respond to Ms Roten's invitation to clarify the relationship between the Joint Research Committee and the Shared Research Agenda. I just want to make it clear that there does appear to be some confusion around that, and conceptually they're actually quite separate. The Joint Research Committee is being set up to administer and make decisions around the $400,000 research fund that the Crown has made available for claimant research. So that's claimant research. And then when the Crown starts talking about the shared research agenda, it's looking beyond that stage really, and looking to the future, and to one way of dealing with further research needs. And the Crown is proposing working with claimants to identify what those research needs are, and then the Crown is also bringing together all the Crown resources in this area, because that's, given the issues, the breadth of the issues and the scope of these issues, it spans a number of agencies right across the Crown. So bringing that all together to make that efficiently available to address some of these research needs. So it's really, it's almost a subsequent process, but we've started work on that so that we're in a position to deploy that. And the relationship is I guess, that the Crown sees the Research Committee, once it's set up, as a vehicle for engagement on that, but it's a subsequent or separate issue to the claimant research funding.
And that's also separate, by the sounds of it, to the data project as well?
Yes, at the moment we see it as separate, but I think there will be overlap. It's likely to be overlap between the data project, and because we'll also be drawing together all the Crown resources for that as well at the same time.
That's helpful, thank you. All right, well, let's move on to, now that we've touched on it, to talk about claimant and research funding. Now, I'm aware there's been a lot of discussion going on behind the scenes at council level, but also at officials level as well, in relation to this whole topic of funding for kaupapa inquiries. It's not just this inquiry, it's how is this going to be some resolution of this for the future. I'm also aware that there has been an urgent application that's been filed as well. I don't know where that's got to. I think possibly the Crown is going to respond to that. Or
Yes, Your Honour, the Crown is yet to respond to that. I think our submissions are due next week.
So in terms of what we can usefully discuss here and now in relation to funding, when there seems to be a lot of matters which are in train, I'm really not too sure as to whether or not there's anything that we can, in terms of this tribunal and its decision making, make any decisions that are going to that will feed into the broader decisions. But essentially those discussions are going on at the moment at, as I say, at officials level, but perhaps Ms Roughton, are you the right person to address this on behalf of Joint Council? And then I will open it up to anybody else who wants to add anything additional.
Yes, I just referred to, I know that the Crown provided a lot of detail around the discussions that have been happening in relation to claimant funding, but just to say that at the moment, so we, several council attended the 10th of September hui. That was put together by Crown Council, and there was particularly a member of Te Arawhiti there to present the proposal there. So at the moment, we're just working on how we're going to approach this issue of claimant funding, particularly within this inquiry.
It's funding for engagement, and also, you know, we have attendance at events and hearings and all those kinds of costs, as well as additional research funding. Is that correct?
Yeah, so there's, as I see it, and perhaps Ms. Theron can correct if I'm wrong, there's two separate, so within the Ropu's funding of the Mana Wahine inquiry, there is, I think it ends up, I think we're back to pretty much at 13% of that overall budget is for claimant research and claimant engagement. So there is an engagement fund there that is really in relation to Crown officials' engagement with claimants throughout the inquiry. I know that there has been, from memory, I think it's $40,000 made available for some hui, which may be able to be used through this research process, but in relation to engaging with the claimants on the research program. So that claimant engagement fund is separate. Then Te Arawhiti looking at claimant funding generally, and within that they've utilised the model that CFRT has used in the historical district inquiries. So they're looking at claimant research, also hui funding, as well as hearing preparation and attendance costs. So they're looking at those three categories. So at the moment, I know that Ms. Theron has sent to myself, which I sent out to all Claimant Council and all the various kaupapa inquiries, so beyond Mana Wahine, the detail that Te Arawhiti requires from the various claimant groups. And so that's, in the other inquiries, that's just left to however Claimant Council and those inquiries are going to deal with that, whether it's a coordinated approach or whether Claimant Council provide that detail individually. But in terms of, my understanding is there's going to be a delay now with the change of government, which has an implication particularly for Mana Wahine in terms of the funding of the tuapa hearings. So we're just seeking to engage with Crown Council to discuss a special case for those hearings and see if we can resolve claimant funding, particularly in relation to the tuapa hearings. That will obviously directly impact, I know we are to talk about hearing location, so that will directly impact hearing location. But there isn't much more aside from that update that we can provide at this stage. Thank you.
Is there anything else that other Claimant Council want to add to that? Okay, Ms. Theron?
Thank you, Your Honour. I can confirm that there are these two processes running, one led by Te Arawhiti, which is looking at the issue as a whole, and that's across all the kaupapa hearings, and those are the three areas which Ms. Rautin identified are the gaps that at a preliminary stage have been identified, and that's costs of attendance at hearings, internal claimant costs and research. And but the Te Arawhiti is also asking for feedback and consultation around all of these matters. So and that process will take longer than will work for this inquiry and for the tuapapa hearings. So in the interim, we've asked for the claimants to identify the costs and let us know what those look like, and then the Crown has undertaken to look at other ways of covering those while the larger process proceeds in the background.
We're going to come obviously to the planning for the tuapapa hearing shortly, but certainly just to indicate in terms of the timetabling for those hearings, you know, we as a panel are operating under some constraints, and I mean we have confirmed those dates for February, and if you know we weren't able to proceed with those because of funding reasons, that would, you know, really mean that we would be not able to reschedule until July, essentially. So certainly, for my own selfish reasons, I would really be loath to let those hearings go in February for reasons of budget. Now, obviously, we can discuss locations and things like that, and those are obviously going to also impact on budget. But certainly I just wanted to indicate strongly that because of reasons of availability during the course of 2021, I would really like to proceed with those hearings in February. Yeah.
That's understood, Your Honour, and we're all proceeding in good faith, and
Yeah.
if I can just urge the Claimant Council to get the costs to us as soon as possible so we can have a sense of what those are, then we may have greater comfort.
All right. Well, obviously, once we talk about locations and things like that, that'll feed into likely costs. So perhaps if we move to were there further comments you wanted to make?
Not at this stage, Your Honour.
Okay.
Thank you. Thanks.
All right. Well, if we just leave the issue of now of claimant and research funding now, and we move into the talking about the planning for the tuapapa hearings. So, Claimant Council, Ms. Ratton, are you going to lead the way on that?
Thank you, Your Honour. So we provided some submissions in the Joint Memorandum of Council, so that's document 3.1280, on the hearing dates and timetable. So there is general agreement to the dates of the tuapa hearings in February. I think there's just some concern around the first hearing week because of its closeness with Waitangi. However, I just heard from Ms. Hauraki of Kahui Legal that looking at the two alternative venues that we indicated in the joint memorandum, I think it is the Te Konahu Museum. It's the Te Ahu Centre at Kaitaia is available for the 3rd to the 5th.
I would have been very surprised if the Waitangi venue was available for those dates.
Sorry, I got that wrong. So some work has been done to establish that venue is available for that first hearing week. And just on so we prepared and attached a possible timetable moving forward towards the tuapa hearings. And just to note, most of that timetable was put together by Kahui Legal. So I just made some additions to it and putting in some aspects for the wider inquiry so that we can begin the process of, for instance, discovery before we get to the end of the tuapa hearings. So I'm not sure if anyone from Kahui Legal wants to speak to anything there on that timetable. But aside from that, I think we'd put in the alternate hearing locations and that timetable, and I don't think there's anything more to report aside from those matters there.
Certainly, looking at the timetable, we've already passed the first date, and that relates to essentially participation eligibility. And as I understand it, the Crown has submitted that they need some more information from claimants in relation to the issue of eligibility before that can come to the tribunal finally for those decisions to be made. So presumably if that is the case and we run with that, that's going to involve a bit of time, which is going to set us back in terms of this proposed timetable. I just make that observation.
Thank you, Your Honour. Yes, it will to some extent. Obviously, the discussions around discovery, that should still we should be able to file memorandum continuing on that track.
Yeah.
And I don't think even the questions of eligibility, even if we can, if claimants and the Crown in terms of the putting together of the arataki or the first statement of issues, that could also move forward. Obviously, we'd just need to wait until the eligibility had been determined. We might have to remove some issues depending on claimant participation.
Yeah. No, I think you're right. Some of those matters can go and be worked on in parallel.
Yeah.
But I'm also aware, obviously, that this issue of eligibility and who are the claims participating potentially impacts on the, the research committee piece as well. So, there are a few sort of interconnected pieces that we need to line up. I think we do have eligibility on our agenda for the day, so we'll be able to hear from the Crown just in terms of what it is that what more they want from claimants. But certainly, that doesn't mean that some of those other matters, as you say, can't
move forward. Thank you, Ma'am.
Yeah. Okay. Thank you. Ms. Hauraki, did you want to make any comments on the timetable at all, or?
Not particularly. I think probably the only other thing I would mention is that amongst the claimants we had been discussing holding a claimant hui to develop the sort of arataki for the tuapapa hearings, and those discussions are still sort of ongoing and will hopefully feed into the dates that we've proposed in the timetable. But yes, that's probably all I can add.
All right. Okay. Any other claimant counsel? Ms. Hall?
Yes, the New Zealand Maori Council had offered to host tuapa hearing number 2 in week 2, that's the 24th to the 26th of February in Rotorua. It's still there as an offer. I noticed it's not on this list, but if it could be added to considerations. Why we asked for it is that the dates come just before the triennial election for the council, which is on the last Saturday of February of every triennial election year. And 2021 is a triennial election year, so if it could be held at a venue like Rotorua, then Whakatane, Hamilton, Tauranga, Rotorua, the women could stay for the whole of the hearing. They wouldn't have to leave early because they've got to get home to get their committees organised for the next day. That's why we were just offering that as an option.
What would be the venue that you would be contemplating for?
Oh, it'd be at that time of the year. It'll be one of the venues, either out at Oahu, where we have the stream there that's beautiful, or it'll come to Rangitaurere and over to Mokoia. It'll be a lakeside, waterside venue.
Okay.
It'll be cool.
Right. Okay. Certainly, with proposing that these hearings move, through the country in sort of a broadly a north to south direction, is for the purpose of ensuring that we have, a wide, we are accessible as a inquiry to, a wide range of people who may wish to come and attend those hearings when they're held. So, it would be my wish that certainly hearing number 2 would be a broadly central North Island location in its widest sense, and that a third hearing might possibly be potentially in the southern part of the North Island, and if we got to hearing number 4, that we would hold that in Te Waipounamu. We have Aroha Rereti Crofts, who's a claimant, the 381 claimant who's from Tuahiwi, so who knows, she may offer her marae to us for a hearing. But I think that the tribunal doesn't often get to sit in Te Waipunam, and for a kaupapa inquiry of this nature, I think that would be an appropriate aspiration for us as an inquiry to take our inquiry to Te Waipunamu. So we've had a confirmation that the Kaitaia venue is available for those dates.
Yes, and Miss Evans has just put in a placeholder booking in the event that the tribunal did want to use it.
All right, okay. So as a venue, as a place that would, in terms of accommodation options, travel, links, in terms of Wi-Fi capability and, all of those kind of things that are necessary for a hearing of this nature, that clearly there are some advantages there. Does anyone else have another strong view in terms of where we should be holding Tuapapa hearing number 1 in the north?
Ma'am, it's Ms Mason here. I just had a suggestion from Mrs Mirimangu, who's the chair of the Ngā Poirunga, and she has suggested the Kerikeri Turner Centre.
Well, I guess, again, the issue is whether or not that is available during those dates. I mean, I'm aware that often the iwi leaders are sitting there at that time. So, do you know if it's available?
Ma'am, I could find that out and then pass it on to the coordinating council.
All right, thank you. Appreciate that offer.
Ma'am,
Ms Loader.
Further to the memorandum filed on the 2nd of October, we've just in light of the tribunal directions that highlighted Tauhinare marae, Akarama marae and Te Rangaparawa marae as possible options, as the claimants that we represent are members of those marae. I've been in touch with them about this, and they've said that all marae are suitable and available to host. They have hosted tribunal hearings in the past and would meet all of that criteria that you have described there.
All right. Thank you. And I also note that your claimants had raised some concerns about the dates. And I guess, the upshot of that is that, it is a very busy time that particular week for everybody, and I recognise it's a busy time, particularly for our wahine in the north. But again, it's really just a matter of panel availability and where we can fit those hearings in. And the dates that were suggested in your memorandum, I don't think we have panel availability for those dates. So.
Thank you for acknowledging that, ma'am.
All right. So clearly we will be wanting to make a decision on this as quickly as we can so that we can lock in a booking as the year moves on. So Ms Mason is going to check to see whether or not, her client is going to check to see whether or not the Turner Centre is available. We've had an offer from Ms Hall in terms of the second hearing for Rotorua. We have had confirmation that the Kaitaia venue is available, and also from Ms Loader that those marae are also available. So we will take all of that on board, and we will have those discussions within the tribunal, and we will give you a decision on that as quickly as we can. So we've talked about, the physical arrangements for the hearings. In terms of the program for those hearing weeks, in terms of the timetable that has been, it's just disappeared off my screen. The timetable that has been filed. Right, if we could just go back a little on that. Okay, thank you. So certainly looking at that draft timetable, we would be wanting to confirm a venue a long time before the 27th of November, so as quickly as we can there. Obviously in parallel with a number of these matters, we're going to be working on the issues of participation and eligibility as well. So some of those things are just going to have to be working in parallel at the same time. So in terms of, I see there is a date, claimant evidence due. So for tuapapa hearing number 1, there is a date of the 20th of January. So do I take it that the process that is contemplated is that some form of brief or summary or outline of the evidence is to be provided in advance, and then that evidence is to be presented or given at the hearing, and then those witnesses will be available for questions from the tribunal. Is it contemplated that other claimant counsel would be questioning those witnesses, or how is that? What is the proposal there? What is the thinking? I mean, I know we've talked about the Crown being given leave if they seek it to file evidence in response, but in terms of the questioning process, what is the thinking?
If I'll answer, and please jump in if I'm speaking out of turn. I think the way that we had envisaged it, at least, is that it would be largely just driven by the claimants, and that at each of the tuapapa hearings there would be sort of a key witness that would sort of set the direction for any other further evidence that was presented. So at least from our point of view, we hadn't really envisaged that claimant counsel would have any sort of role.
Yeah. So it would, in its best version, it would be a discussion after that evidence is presented, hopefully a dialogue or a discussion between the tribunal and those witnesses in terms of what they are presenting.
Yes.
Yeah.
If I may, yes, we certainly would have thought that we would have perhaps 1 or 2 or perhaps even 3 women from the area who are nominated, selected, however it's done in the region. If it's done, hosted at Rotorua, there'll be a way. And the women will probably come from Mātātua, Tauranga Moana and Rotorua, who would address the room. Then for the discussions to go from there would have been how I think they'd want to do it. But if it was just us running it, that's how it would happen.
Yeah.
There's a general theme on the topic, but people are invited to come and they'd put up a lead speaker for their region.
Yeah. Well, it's definitely not intended to be at all an adversarial process. That's why we're holding these types of hearings, and but in order, obviously, for us to enter into, as a panel, as a tribunal, to enter into that dialogue and discussion, we will obviously want to have some idea as to what is going to be discussed, so that we can think about it and maybe think about the sorts of issues or questions that we would want to be asking. So certainly for myself, that's...
Well, there would be 4 district councils that would contribute to any hui. Let's just say it's held in Rotorua. And each district council would have a view. I just know that there is 1 or 2 that instantly come to mind who will be invited to speak. Dr. Kathy Dews, to give a perspective. Others will similarly come in from Tauranga Moana and on the Mātātua side, and then the debate goes from there.
So, as I understand it, the hearings will be themed. Is that will be focusing on different themes at each of the hearings? So obviously we have the fact that we're moving through the country into different districts and different areas who have different approaches or histories that they will want to talk to us about, but will also be, the hearing will have a broad theme. Is that, I'm sorry that sounds very generalised, but I'm just trying to grasp it.
No, that's fair enough. I think that we suggested those sort of 4 broad themes,
Yes. Yeah.
and had initially kind of imagined that you would that each of the hearings would follow or sort of predominantly feature one of those themes. However, it's quite possible, and considering it now, that moving through the country, you would touch upon each of those 4 themes at each hearing, and that the witnesses would offer their own kōrero around those particular topics at each hearing. So I think there's probably a bit of work we need to do around how to sort of present that in a coherent way.
Okay. So, I mean, obviously, you know, there needs to be some space within a hearing for things to evolve, as they often do on these types of events, but we'll also have an agenda, I guess, in terms of the material that we will be expecting to cover during the course of that hearing, which will be focused on the theme, but also maybe looking at that rohe as well, and in terms of their experience and their history.
Yes, and I think that the hui that we proposed to have with the claimants sort of at the outset was to try and shape how the hearings might evolve.
Okay, very good, thanks.
Oh, sorry, one further point if I may, ma'am. Just had a message from one of our clients who's proposed a couple of other venues for the 2nd and 3rd hearing weeks. So I'm not familiar with them myself, but there is the Te Kohanga Nui Chamber in Naruahia, and she has suggested a Ngāti Raukawa Marae for the 3rd hearing week, but I can probably get more specifics around that.
Okay, is that in Tokoroa or?
I am not sure, but we can file something to shore that up.
Yes, we will give a process for all of this information to be provided to us.
Your Honour, can I just ask a quick question before you move on? Can I clarify whether the Crown will have opportunity to ask questions during these hearings? In the earlier proposals, there was a reference to mana enhancing patai and the Crown having that opportunity.
I can't recall that just that particular piece that you referred to there, but certainly in terms of the opportunity to file any evidence in reply, should you see a need for that to be to happen, that there, you need to do that. But let's just sort of clarify what process that would be.
Just asking questions of the witnesses. Asking questions of the witnesses.
Yeah.
During the contextual hearings.
Yeah, probably more in terms of any issues of clarification, as opposed to any sort of adversarial types of questions.
It wouldn't be in the nature of cross-examination.
No, that it would not at all be my expectation of what we're there to do.
Yes, that's understood, Your Honour.
Okay. All right. Any other submissions, points to be made around the tuapapa hearings process? It just seems we've got a little bit of work to do yet before that's fully coming into focus. Any points you want to make?
I have one more point, Your Honour, and that's just about the timetable, and I would just
say the Crown at this stage thinks any directions in relation to discovery are probably premature and would prefer there to be more definition about the subsequent stages of the inquiry, just to give some definition and scope for discovery. But it wouldn't urge any claimants who want any information to approach us directly, and we can help access any information that claimants are looking for.
Yeah. Well, certainly, I would expect that if there are requests for information to the Crown, that those can be, provided to the Crown reasonably informally. Then obviously if there is any difficulty in obtaining that information, or, at the worst resistance, then obviously discovery is what we resort to. So we can move through those different stages. I want to talk now about, let's move now to the issue of claim eligibility, because this is a process which we are going to have to finalise as quickly as we can, so we have certainty around participation for the reasons that we've discussed already. So many of you made submissions around eligibility previously, and we have had a response from the Crown that more information is required. So, Ms Teron, could I just ask you to elaborate on that?
Yeah, perhaps I could provide some clarification that might help cut through it. Your Honour, the Crown set out our position in some detail in the submissions which we filed on 16 September. And the further information sought is in relation to whether the claims include historical as well as contemporary claims, and in relation to whether claims arise by virtue through whakapapa to a settled group. And both of those issues, they're two separate issues. There's one around the interpretation of settlement deeds effectively, and that filters back to the tribunal's jurisdiction, because the tribunal doesn't have jurisdiction in relation to claims that have been settled. And Your Honour, we'll see in that we have acknowledged in our submissions that there are tribunal determinations that have gone against the Crown on those issues, and I should actually add a reference at footnote 6. There's a reference to the Y2700, the Veterans Inquiry determination, and there's also a more recent determination, Y2800, the Remaining Claims Inquiry, and that document is 2.5.5.
Sorry, what was that later inquiry?
It's the Remaining Claims Inquiry, 2800. So the tribunal found against the Crown on that issue, the issue around whether the extent of the settlements, and whether if claimants define themselves by reference to another commonality other than whakapapa, whether that means their claims are settled or not. And then similarly, in relation to the other issue, which is around, it's really a limitation issue, whether the claims have been filed within the deadline before or after 1 September 2008, and the Crown's position on that is that claimants can't get around that deadline by attaching an entirely new claim to an old claim, but the tribunal's also found against the Crown on that in Y2800, and that's Y2500, and that's at footnote 14. So the information that the Crown has requested goes to both those points, and if this tribunal were to indicate where it was sitting on those issues, then that would tell us whether it's necessary for us to go and do that further analysis, obtain that information.
Well, I guess my question to you would be: are there any additional features or new or special circumstances in relation to this inquiry which would lay the foundation for us to make a different decision to those decisions which had been made by previous tribunals on what are quite you know, they're not necessarily specific issues, they're broad issues, aren't
They're
they,
more
of
general.
broad general issues of eligibility.
And the Veterans Inquiry is a kaupapa inquiry
Yes.
like this one, and the other one
Yes.
is a district inquiry. So I
So
don't
I would
think there
be-
is anything to distinguish this inquiry from the veterans on this topic. But Your Honour will appreciate these are really important issues for the Crown.
Indeed.
Because of the implications beyond any one inquiry. So it's very important that we record our position and that the tribunal understands that. But I'm just
All
offering
right.
a way through depending on where the
Yes,
tribunal
yes.
gets to.
And I think probably the way for us to approach that is, as you suggest, to give our indication as to where, you know, what our approach is going to be on that and that issue. And if our indication is that we see no particular reason why we would make a different decision on those broad issues of eligibility than particularly the military veterans, which is also a kaupapa inquiry, then there would be no necessity to then
go through process.
that additional information being provided on eligibility, and presumably then we would be able to get to a position of certainty around participation claims more quickly.
Yes,
Yeah.
Your Honour. And we have done quite some analysis, and we hope that is of assistance to the tribunal.
Yes.
But if there is more analysis
Yeah.
we can do, we're happy to do that as well.
Yeah, no, we can. It's evident how much work was put into that. So and certainly that's very clear and full analysis of the issues. It's very helpful. Thank you.
Your Honour.
All right. Well, that's a sort of a. Yeah, so really, the next step is for the tribunal to make our view clear on that issue, and that might, if as I indicated, we were to take the same position as the military veterans claim, then we would be able to arrive at a position in terms of confirming participating claims earlier than we would otherwise be able to do. Any other submissions that Council wish to make on that issue? That was a helpful discussion. Thank you. All right. We seem to be getting towards the end of our agenda. Are there any other matters that Council wish to raise?
Excuse me, ma'am, Ms. Te Whenua speaking.
Kia ora, Ms. Te Whenua.
Kia ora. With respect to eligibility of claims and claimant participation, as I indicated earlier, we were amongst those that made a last-ditch application, essentially, to file on behalf of claimants who had not previously filed with an intention to participate in this most recent tranche. I wondered if the tribunal would be in a position to indicate, if Her Honour would be in a position to indicate when you might be considering those submissions to participate.
As soon as possible. It would be my intention to confirm and finalise issues of participation and eligibility as early as we can. So at this stage, before making that decision, I'm not anticipating requiring any more submissions from parties before that decision is made. Then obviously if we decide that no, we need you to all jump the fences and go through the barrels, well then we will issue directions to that extent. But the next step for us is following this judicial conference to consider the matters we've discussed here today and to issue some further memorandum directions which will give you our view on that issue. Does that clarify that?
Yes, thank you.
Okay. if there are no further matters that council wish to raise, we're rapidly running out of things to talk about. And I know that we had planned to provide some afternoon tea at 3:30. I'll just check whether or not that's possible to bring that on earlier. Okay, we're just seeing if we can come early. There must be something we can talk about, surely. A room full of lawyers? Come on.
Excuse me, ma'am, Ms. Stefanoa, again. To prolong anything, but I did have a question which I would like to direct to the Crown, just to clarify my own understanding of around the claimant research funding, and what I now understand as a result of Ms. Theron's presentation today, what sounds like a two-pronged approach. One being the 400,000 fund available for claimant-led research, and the second being a type of mop-up approach to research not yet covered with respect to the shared research agenda. Is that correct?
I probably wouldn't characterise it as a mop-up. It's two-pronged in the sense it's another way of coming at the research, and it's so it is conceptually separate, but it's looking ahead to the broader inquiry past the contextual hearings and past this beyond the $400,000 research to ways in which we can get the research that needs to be done. And to the extent that the Crown has resources that can be deployed, we're bringing those all together, and we're wanting to discuss with claimants and claimant counsel how best we can deploy those and what topics the resources can be directed towards. So it's more than mop up. It's a way forward to address some of the research needs. Does that answer your question?
Yes, thank you. The reason why I asked the question was also to bolster my understanding around, or perhaps it's an additional follow-on question really, is around the parallel process which was originally spoken of by the Crown, which was to run in parallel with the inquiry, but to support more immediate policy change and respond to some of those contemporary issues of inequity that Wahine Māori face. And of course that's quite a prominent concern for my claimants, being in employment but also in issues of inequitable levels of harm. So is it that, has the parallel process been considered in this two-pronged research approach?
I think what you're talking about may be a policy process which almost sits outside the inquiry process, and the Joint Ropu is doing work around policy in this area, addressing issues raised by this inquiry, and so that is happening in parallel, and there will be opportunities to engage with the Joint Ropu on that process as well. But it's another process entirely as a policy process.
And the other thing to think of there is that we did have submissions earlier on about research on what alternative remedies might be. And, there was a suggestion that a good place to start with that might be literature review in terms of what literature is available out there on alternative remedies, which may feed into the type of process that you are discussing there. And The other point just to highlight, of course, is that, there are 3 identified pools, I guess, in terms of research. There is the claimant research funding. There is what Ms. Teron has identified just now in terms of future-focused research needs that may be identified, which ties into what I've just talked about. And then, of course, there's the tribunal commissioned research as well, in terms of the casebook and where we get to the reports that will be commissioned as a result of that process. So I just make those comments just to sort of pull those different strands together. Ms. Rowden?
Just to add, Your Honour, there's a 4th area which may also be claimant research that's funded by legal aid. So that's another way to get any further gaps after those 3 processes are fulfilled.
And once the tribunal confirms its commissioned research, and makes any comments or recommendations in relation to what might be some further research that could be done, that will obviously feed into any legal aid applications that may be made to fund further research. All right. Okay, well, I feel as if we have reached the end of our agenda today, and I can see from the corner of my eye that the afternoon tea has arrived. I'm going to draw matters to a close for now. We will be issuing some memorandum directions in the next week or so in terms of the next steps. So I want to thank everybody for their attendance and participation today, and I will ask Dr. Hond to close us for the day.
E kore kaha te ki ko pau ngā haora o te rā, i te mea he haora tonu e toi ana. Whakaaro mehe wānanga, ka waiho atu ma te reo Māori, ka haere tonu, ka tahi, ka pau te haora. Engari anō, a puna kōrero, ko mimiti, ko pito kōrero, ko pau te pito kōrero, ko konga noio, ko tai ki tēnei te hiku mutu ngō a tātou kōrero mo te rangi nei. Engari, hikaka katoa nei au, kia ruku ki tēnei mea te tū a papa. Ki au nei me Māori anō, te rāhuatanga o ngā kōrero tū a papa. Kia kaua e ki waiho atu te kōrero roia, engari anō me kōrero Māori nei. Nō reira koia nei au hikaka ana, kia haere ki runga marae, o mehe mea ka haere ki tētahi wahi, me Māori anō te kaue i e rā ahuatanga. Ko te tūmanako ka haere ki tētahi wahi, he nui anō ngā kōrero hono ki ngā wahine rangatira o roto i e rā wahi. Kia whai wahi nei, a tama wahine kia tū ki roto i te hui huinga. Nō reire mihi ana kia tātou e noho tahi ana. E harei te mea he tāmi ngā kōrero kua puta, he whakaaro ōku he apiti atu ki ngā kōrero kua puta. O tira, i mua anō i te karakia, kai te ki atu, ko au tētahi e rata ana kia tū a waine ki te mihi. Nō reira, he kōrero tēnei i tēnei wā, mehe mea ka hoki mai ki konei, kei te pai anō, a tama wahine kia tū ki te whakautu i aku mihi whakatau i a koutou. Kua kore he aukati i te rataha. Kore aukati nā te mea ko oku kuia, he kuia karakia tawhitone. Nō reira, e kore au e whakahei i a ratau e tū ki te karakia. Nō reira, a tōna wā, ka hui anō tātou ki konei, mehe mea pirangi ana ngā kuia, ngā wahine ki te tū ki te karakia, ka wātea koutou ki te tū ki te karakia. Ka noho au ki muri, ka tuku atu te Māori o te karakia ki a koutou. Nō reira, mehe mea he kuia kai roto i a koutou, ka tō ia mai ki pōneke, ka pai anō ka waiho maratou, e rā wā āhuatanga e kaue. Ko te mea nui nei ana, ki atu ana he arataki o tātou whakaaro kia kotahi, kia eke atu ki te taumata e tika ana. Nō reira, tēnā koutou, ngā tēpu katoa o roto i te rūma, kua puta te kōrero, no reira, koe ke atu i tēnei wāhanga, he whakakōpani a tātou kōrero. No reira, ho mai manawa nei e tū, ho mai tō wairua ora he ora. Ko tō manawa, ka taku manawa tēnei, uki tō manawa ka tīnā tēnei, uki tō manawa ka toka tēnei, uki tō manawa ka pau tāiki. Tīnā no o tō manawa ora e ora, ko tō manawa, ko tōku manawa, he manawa ki mi ia, he manawa ki rawea, he manawa ora, he manawa wahine, he manawa tēnei anō kārongo e whētuki ana i roto i te whare i te rangi nei. Turuturu ōwhiti whakamaua kia tīnā, ui e. He waiata kina ki nei ana, he karaki anō te ahua o te waiata. Ko te pū te more te weu te aka te rea. Ko te nui te kune te whe te kore te pō. Ko ngā tangata Māori nā rangi raua ko papa. Ko tēnei te timatanga o te ao. Ko tēnei te timatanga o te ao. Heti anō, ana ki etahi ka ki a ko io, ki etahi anō ka ki ko rangi ko papa. Ana, no reira ka haere ki runga i a papa tuanuku, te whenua e takoto nei, kia haere ki runga i aia, kia hoki pai ai koutou ki o koutou wā kāinga, kia noho mana whenua, kia noho mana tangata, kia noho ko tēnei mana wahine ki roto i a tātou. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Ko pai ngā atu.